everybody. Welcome back. Welcome back. Happy Tuesday. Congratulations to you Celtics fans. What a win. Oh, gotta tell you, I don't watch NBA. I'll just put it out there. So this wasn't something I was super into. But I know what it feels like for your team to win a big championship. And boy, you guys are riding high today. So congratulations. Enjoy it. It's a great feeling. Well, are we ready to hear from some real experts today? We get the voir dire. We get the voir dire of the defense experts. I went ahead and went back and pulled up the Commonwealth's motion that generated all of this. It's the reason why we're having this hearing. I'm not going to share it because I tried to. I don't have it in a good format, and it won't share big enough to be able to read it on the screen. But I'm just going to share with you the general bits about who we're talking about and why we're here. So the Commonwealth wrote on April 15th, 2024, the defendant identified Chris Van E., PhD, as a potential expert witness in biomedical and mechanical engineering. The defendant proffered that Mr. Van E. will testify regarding his opinions and conclusions regarding the Commonwealth's reconstruction and the EDR data obtained in connection with this case. He will testify to the chronological data derived from the EDR, including key cycles and triggering events from the time period in question. However, this description fails to comply with Mass Rule of Criminal Procedure 14A sub 6, which requires the defendant to disclose the opinion rendered, all intended opinion evidence, and any reports prepared by the expert. So he said that this is a rebuttal. You know, the defense has disclosed this as a rebuttal. His opinion is going to depend on what the testimony is that we heard yesterday from Old Trooper Paul. And I have a feeling his opinion is going to be like, well, so I can count. My opinion about key cycles is that I can count them. It could not have been this key cycle that he's identified as having these triggering events that look suspicious to him, that look consistent with a vehicle pedestrian collision. But we'll see. You know, the guy's got a PhD. He can certainly at least count. But we'll see. We'll see what else he might have to be able to offer about that. He refers to it as chronological data, which I find interesting because that's the chronological. It implies that it gives a sequence, not necessarily like a clock time, which is I find it strange that there's nothing in this data that would have a clock time like that, embedded in it or something. Just because if this is supposed to be for reconstruction or for diagnostic purposes, it seems not very helpful to have that associated with a mileage. If I bring my car into the shop and I'm like, yeah, I was driving it the other day and it did this weird thing, I'm not going to know what mileage that was. I'm just going to know it was like 2 days ago. So it seems strange to me that that's not there, but apparently it isn't. And what they have to do is go through these sequences like that to just see kind of what happened in what order. But maybe he'll explain that. Maybe he'll explain all of this in a little bit more detail for me with his PhD. Then the biomedical has got a nice ring to it, doesn't it? I mean, I certainly hadn't heard the Commonwealth's theory before that the car backed into his arm and broke the taillight that way, and his hand holding the glass hit the car and gouged it, and all of this force on his arm didn't hit him anywhere else because he had no bruise. All this force on his arm projected him 30 feet and in a spin in the air, and he didn't drop the glass, and the taillight scratched his arm. This is the first time I've heard the Commonwealth just say outright what exactly they think happened here. So I am very interested in his response to that. I'm assuming it might be accompanied by a chuckle, but we'll see. We'll see. So the motion goes on. The defendant also identified 3 experts from ARCA LLC, Daniel Wolf, PhD, Andrew Rentschler, PhD, and Scott Klein, BSME, that's a Bachelor of Science in Mechanical Engineering, as expert witnesses in accident reconstruction. The defendant testified that each expert will testify consistent with report in possession of the Commonwealth. Pursuant to Massachusetts Rule of Criminal Procedure 14A sub 6, the Commonwealth again moves for the defendant to produce all written reports and opinions that pertain to this case and the identity of anything upon which the expert bases his opinion. The Commonwealth also moves for the defendant to specify what each of the 3 experts did, what their independent opinion is, and what each expert would testify to. Further, a voir dire is necessary to determine whether each of these 4 proposed experts are qualified to render an opinion about crash reconstruction, whereas all 4 proposed experts are biomechanical engineers and not crash reconstructionists. Read that again and think about that. A voir dire is necessary to determine whether each of these 4 proposed experts are qualified to render an opinion about crash reconstruction, because they're biomechanical engineers, not crash reconstructionists. So is crash reconstructionist like a thing? Is that a specific thing, like a specific title, certification, qualification? Do you got to get a license from the state to be a crash reconstructionist? Or is that just a kind of descriptive title based on the function of the job, what the person is actually doing? Because we know Mr. Lally is not getting up here and saying this AA guy, this AA guy who just testified, Trooper Rimmer over here. I'm calling him Trooper Rimmer because I had to watch this again last night. I watched it with Ian Runkle on Runkle of the Bailey. I had to see Ian's take on all this. And he made a Red Dwarf. He made a Red Dwarf reference. And it just, reminded me of another Red Dwarf reference. I can speak cowboy. It just reminded me, this guy is that. I can speak cowboy. So he's Trooper Rimmer to me now in my mind. Trooper Rimmer, the AA guy, who is just kind of pulling stuff out of his fever dream. He is qualified to testify about crash reconstruction, but the PhD educated, certified, licensed biomechanical engineers, they're not qualified. I mean, it's nuts. It's absolutely nuts. But there it is. It's on paper, black and white. That's what he is claiming. And then lastly, on May 21st, 2024, the defendant provided the Commonwealth with the curriculum vitae of Dr. Marie Russell, an expert witness not previously disclosed. On May 30th, 2024, during the 6th week of trial, Attorney Little provided the following synopsis about Dr. Russell. She has reviewed the autopsy photos, grand jury testimony of Dr. Scordy Bello, the entirety of the autopsy report, all reports associated with Chloe's prior bite history, photographs of the items in evidence, and the UC Davis DNA testing results and evidence submission forms. She is expected to be called with focused testimony related to the right arm injuries sustained by Mr. O'Keefe. Dr. Russell will testify that the wounds and injuries on Mr. O'Keefe's right arm are consistent with an animal attack, namely teeth or claw marks, or a combination of both from an animal. She will also testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. She will base her opinions and conclusions, in part, on having treated hundreds of patients in the ER with injuries sustained from animal attacks, including dogs. No written reports or opinions from Dr. Russell were provided. So the Commonwealth is basically, for the most part, complaining that the specific opinion has not been disclosed, which again is real rich in light of what we saw them just now trying to do with Trooper Paul and slip in this last minute undisclosed opinion about, well, the taillight couldn't have been broken at 5 a.m. when she backed into John's car because it doesn't look right to me. Not that I did any measurements or did any math or calculations or anything like that, but it just doesn't look right. I just don't see it. Kind of like, the phone landed under him because it just did. I can't explain why. I don't know the mechanics of that. It just did. It did because it needed to for this to have been a motor vehicle pedestrian collision. And so that's the gist of their complaint. You haven't been specific enough about what their opinion actually is. And, there's some legitimacy to that, I think. I mean, I don't know what in total the defense has actually disclosed. If they have disclosed experts, like reports that these experts have prepared, then the report is typically going to lay out, this is what we looked at, this is what we did, these are the conclusions that we reached. So at least for the ones that have prepared reports, I mean, typically, the disclosure of the report is going to be adequate. And if you have more questions, then set up a deposition, go set up an interview, do whatever you need to do to get your questions clarified. But, exclude them. No, very, very unlikely to happen. Very unlikely to happen. Dr. Russell is a little bit of a closer call because she is disclosed so late in the game. But the argument here is going to be, well, the DNA person from UC Davis testified, and that's the point when we knew we were going to have to kind of double down on disproving or at least proving that this could be a dog, that it's consistent with a dog, our theory, and disproving that, this had anything to do with the arm hitting the taillight. Some of this stuff, you wish it would be common sense. Like, can't we all look at that? Can't we all look at that? We're not even medical people, and we can look at that and go, no, that didn't happen like that. Maybe we don't even need an expert for that. No, we do. We want an expert for that. So some of this may just come down to, why is this late disclosed? I don't know. I don't know that we've gotten an explanation for that. I can tell you just from experience, working with experts, sometimes it can be extremely rewarding, but it can also be one of the most frustrating parts of trial preparation and investigation, because you're really at their mercy. You're at their mercy. You need them. They don't necessarily need you. They got a lot of people that are waiting to pay them for their opinion. And you got your demands from your court, your case, your timeline, when you got to get these things done and so forth. And you really want the expert to be committed to that with you, but you just don't always get that. You just don't always get the perfect combination of the person with the expertise that you need and the ability to communicate it to a jury, and attentiveness to the process, concern about your end of the things, your obligations, the timely disclosure, the requirements of the rule, and so on and so forth. So it can just be, it can be really, really frustrating dealing with experts. I don't know if this is a situation where they hired her late. I don't know when the UC Davis DNA was disclosed. I can definitely see a scenario where, okay, the UC Davis DNA, the DNA analysis is disclosed late in the day. So they're rushing to get somebody on board, and these guys are busy, These guys have a lot going on. They're not going to and shouldn't be expected to drop everything just so that they can comply with the timeline in your case, because, the Commonwealth chose to hold on to this stuff for so long. So that kind of situation, if that's what we're dealing with, you typically get a lot more leeway with that. And frankly, the voir dire, the fact that we're having the voir dire at all, assuming that it's not going to be just limited to what are the qualifications of these people, because we wouldn't need all day for that. We would get their CVs, we would provide them to the court. We probably wouldn't even need to really have a hearing at all. But they want to go into a whole song and dance about is this a valid opinion? Is this something that they can even really testify about? And the Commonwealth goes into this a little bit further. They say Dr. Russell, the proposed testimony may necessitate a Daubert-Lanigan hearing where the defendant bears the burden of establishing that the proposed testimony would assist the trier of fact and that the methodology underlying the expert testimony is sufficiently reliable. The trial judge must also determine whether the witness has sufficient knowledge of the facts and expertise to render an opinion. Of note, Dr. Russell's expertise is with treating patients in an emergency room and how injuries may appear on living individuals rather than how injuries are depicted on a deceased male and in a post-mortem photograph. Well, she's a pathologist. I mean, David Yannetti made that clear. That's part of her qualifications. She is also an ER doctor, which is a pretty impressive little double set of qualifications there. But so the Daubert hearing, I mean, again, man, coming from the Commonwealth, who put a guy on the stand who said his basis is the crime scene talks to him. The Daubert-Lanigan is the precursor to being able to admit scientific evidence in a number of courts that use this standard, and it just goes to basically whether this is a sufficiently reliable process. You don't normally have to go through a whole Daubert type of hearing with testimony that's not novel, okay? Like, forensic pathology is not a novel science. People make that type of determination all the time in the course of doing autopsies and stuff. So you don't normally have to go through a whole song and dance about how is this expert, able to testify to this. They're trained to examine injuries, and they understand how injuries are caused and how they contribute to death processes and things like that. So you don't normally need that type of a hearing for something like this, but I'm not generally against having Daubert hearings at all. I wish there would be more of them. We don't actually even use Daubert in my state. We follow the Frye standard. These are named after big Supreme Court, U.S. Supreme Court cases that deal with scientific evidence in court. Daubert is generally considered to be a little bit more rigorous. It goes to actual validity of the underlying science. The Frye standard is it generally accepted by experts in the field? So basically, you can sort of cherry pick what you want to put into evidence by how you define who are the relevant experts in your field. And that means if you have, say, a bunch of people that do ballistics, even if ballistics is complete and total horseshit, as long as it's generally accepted among those people who do that, it's going to be, admitted as scientific evidence in a courtroom. Daubert is supposed to be more rigorous as far as getting into underlying scientific principles and has it been peer reviewed and all of these different kinds of factors like that. And I'm definitely not in principle against having those types of hearings. There needs to be some sort of bar that scientific evidence should clear in order to get into court. The problem is just that, number one, the court is a notoriously bad gatekeeper for that type of thing. The whole point of this is that these are experts. They have specialized and technical knowledge that we don't. And so at a certain point, it's just a question of the experts have to sort this out. We need to hear from both of them, and we need to hear their reasons for it. We need to hear how they respond to the other. And then, from that, we do our best to kind of sort out which one we think is closer to the real situation. But a floor is certainly appropriate. It's just that it's more for things that are not routine, things that have been disciplines that have been criticized. I'm not aware that forensic pathology and identifying the nature of injuries is really that criticized. Now, the closest equivalent here is the bite mark stuff, bite mark evidence. Bite mark evidence, definitely problematic. Definitely problematic. There's a whole slew of cases and convictions that arose out of experts claiming to be able to match forensic dentistry, claiming to be able to match specific injuries with somebody's casting of their teeth, somebody's dental casting. And it's just not possible to do that because of the way that the body deforms. You know, we're soft. We're soft. We squish, you know, things you can't really see very well, but you don't have, it's your skin, your body is not like a, whatever the material is that they use for those types of dental impressions. So that's been pretty well established that it's largely bunk. It's largely bunk. And in fact, I remember there being some type of validity test that somebody did where like they can't even consistently identify what's an animal bite from what's a human bite, you know, let alone tie it to a specific person. So I definitely understand there is some junk out here and there are some limits here. But that seems to me to be a little bit different from what's being proposed in this case, which is simply this looks like a bite or a claw. These types of injuries can happen. I mean, that's very unspecific. She's not trying to say, yes, I've matched this to Chloe. You know, I got Chloe's dental pattern and her little paw prints. And these line up. Look at how these scratches line up with her claws. You know, this is not that. This is not that. It's just these look like dog bites. That to me does not seem too far out of the realm of what I would expect a forensic pathologist to be able to testify to, in part because a lot of times they're dealing with remains that, you know, are not pristine. They've been left out. They have to sort out things like, you know, predation. You have a dead body lying out. Animals can come and chew on it and stuff, and then they have to be able to sort that out. That was an issue in the West Memphis 3. I remember that was an issue there because they had injuries that I think I can't remember specifically what the prosecutor was trying to attribute them to, like just, you know, satanic ritual stuff or something. But it turns out, no, it's because the kids had been out and there were scavengers had come in like chewed on them. And so, yeah, they got to be able to identify that thing and rule it out, you know, recognize this happened post-mortem, recognize that this is not, you know, not something that is part of the mechanism of the crime. It's just a natural process that happens afterwards. So it really doesn't seem that far beyond the pale to me. It's just really funny. It's just really funny coming from the Commonwealth, whose expert does math and stuff. Except I don't think he did math. We certainly didn't hear any testimony about any math, not a single math equation that he did. Because I guess to him, you can't calculate. You can't calculate what would happen during an accident unless it's absolutely square on. If he's sideswiped at all, if there's any type of angular momentum involved, that's beyond his capacity to be able to calculate that. So generally not against Daubert hearings, just not really sure that this one in this particular case is appropriate. As to the rest of these people, it looks like what we're really going to be fleshing out is just what is their expertise, what is their training in, what does that mean, and how did they apply those principles in this particular case. So I am expecting, yeah, we should get a pretty good preview of what it is the defense thinks happened, you know, in this case, how How do we know that this is not a motor vehicle pedestrian collision? How do they intend to disprove that theory? And then what can we ascertain about how John O'Keefe died based on the condition of his body? These seem like pretty normal things to be testifying about in the course of a trial. So as far as the complaints about late disclosure, you haven't given us the opinion, all of that type of stuff, the point of this voir dire is to cure that. It really is to cure that. To the extent that you have questions that haven't been answered already by these experts' reports, this is your opportunity to have them answered before the trial is over, when you will still have an opportunity to go ahead and do a rebuttal case. You think Trooper Paul can rebut these guys? Go right ahead. Go right ahead. Put him back on. See how that goes. Oh my gosh, and they actually might. I mean, this is what blows my mind. They actually might try to do that. Crazy to think about. So what else did they complain about here? Let me flip back through this motion real quick. It's mainly late disclosure. They didn't give, in I guess enough detail to satisfy the Commonwealth what exactly their opinion was going to be. Well, just ask then. If you have questions, you don't understand their report, give their report to your experts, and do what you can to sort it out. But that's the problem, is when they are responsive witnesses, when they're there responding to the case that you put on, it's kind of hard to disclose that in advance, exactly what their opinions are, because their opinions are going to depend on what your witness testifies to. If he hadn't testified to this flying through the air, pirouette, cutting the arm, whatever mechanism of injury and death here, if he had said something else, they might have a different opinion, but that's what he said. So that's what they're going to have to respond to. That's what their opinion is going to have to be based on. So, yeah, just seems like a little bit of, I don't know if crying wolf is quite the right expression here for what the Commonwealth is doing, but just really complaining about something that to me doesn't seem like that big of an issue. The biggest complaint I can see is the Dr. Russell being so late disclosed. I get that, but I don't know the circumstances of why that is. And so, if this is a situation where the Commonwealth waited and then disclosed their own stuff at the 11th hour, well then, yeah, you need to expect there's going to be a late disclosure in response because you chose to sandbag the defense, hold this stuff back. Did you think that was just going to, I don't know, be a gamesmanship type of strategy that you can employ, and they're just not going to be able to respond to it then? No, that's not how it works. You don't win the expert game by holding on to your stuff until the 11th hour. So it just comes down to, did they respond in a reasonable time? And, reasonable, it always depends on the circumstances. The fact that they're in trial, okay, you're trying to correspond and communicate with an expert during trial. And, you got a million other things going on. They got other stuff going on. Everybody always knows experts are busy anyway. They are not going to drop everything to do it, to satisfy the Commonwealth on the Commonwealth's timeline. That's just not how it works. They'll make their best effort. And if it's reasonable, then, yeah, it should come in. So it looks like Judge Bev is having a little sleep in today, getting a little bit of a late start. Not so bright and early. But I am keeping an eye on the stream to try to catch it, make sure I catch it when it comes up. Oh, we already got some comments. Might as well go through them, guys. See what you guys have to say. Joe Mendoza, if DA Morrissey told you to prosecute this case knowing what Lally knows about this case, what would you do? Is all this side trial to see why am on Fed? Maybe. I mean, maybe. So I would not be a prosecutor anyway. I would be a terrible prosecutor. I just... too much of what prosecutors do that I personally disagree with. It's just not who I am. Jacques Hughes is really not my thing. I side with the underdog in these situations. But if I had found myself in that position, no. I mean, I just no. This is exactly why. I would be very bad at this job, because I appreciate what a serious effect it has on somebody's entire life to put them through a process like this. I mean, this is a big, big deal. You have put her in jail. She's been in front of the cameras. She's had to spend millions of dollars. She's on national television getting picked apart for every expression she makes, everything she does, every text message that she's sent. They have gone through her entire personal life in just excruciating detail. Yeah, I take that real seriously. I see how that affects people because I work with those people. So over this case with this evidence, am I bringing that? Absolutely not. Of course not. Of course not. And I think, frankly, the justice system would be a lot better if prosecutors in general had a little bit more of a healthy perspective on the enormous power that they wield. Instead of just taking it for granted, it's a thing. It's just a thing to do. And what if they're innocent? Well, then they'll clear themselves. Well, you know, the process is the punishment in criminal justice. A lot of the time, the process is the punishment. So, no, I would not subject somebody to this on this type of evidence. Thank you, Beth B. Appreciate that. Entry required, eager for defendant expert voir dire, Mr. Entry required. I am too. I'm just, I'm ready to see something substantial here. I mean, I would have been fine with substantial evidence from the Commonwealth. You know, somebody who can actually lay down for me what the heck happened here. Show me. Just show me how this is consistent with a motor vehicle collision. That's really all I've asked from the very beginning, because I don't really care if Karen Reed says I hit him. She can believe that she hit him and she can be wrong. You know, if they can't prove that a motor vehicle collision happened, that's consistent with the condition of the car, John's body, all of the information that's available, then I really don't care what she said. So it's just, that's the real fundamental part of the case here. Prove to me that a motor vehicle collision happened. I was all ready for, you know, something technical from the Commonwealth, but we sure did not get that. Our red pen, why not announce in trial that so-and-so will be accepted as an expert witness? Every other court I've watched requires the attorney to ask judge for expert status in front of the jury. This is just a convention thing. In some places they will not do that because there's a suggestion that it puts more emphasis on this witness. It suggests that like they're special compared to the other witnesses, that they you know, deserve more attention from the jury or something like that. So they will not. And there's other places too where the judge doesn't necessarily make a formal ruling on whether the expert is qualified, because they are just basically determining, again, like the floor. Okay, has the floor been exceeded here? Is there enough that a juror could find them to be qualified? And then that's all they're really vetting in terms of the expert's qualifications. So they wouldn't make a determination that this person is qualified as an expert. That's just left for the jury to decide, do we think this person is really an expert or not? And if we don't, then we just disregard, the opinions that they've provided. So it's really a convention thing, depends on the court, depends on the state, the jurisdiction that you're in, and the rules that they have. I've seen it done. I've seen it done both ways. I've had it, been in courts where, yes, you do that, offer them, formally qualify them as an expert. So I don't really hate it one way or another. I kind of like it, I think, maybe when they don't do that, because it does seem like, oh, this, then it imbues them with this aura of, well, they're really special and important, when they're really not. They're just another witness. They just happen to have some type of specialized knowledge that allows them to be able to offer opinions on things that those of us without that knowledge, we wouldn't be qualified to have that type of opinion. NJ Kathy, and this is after the prosecution put one idiot after another on the stand, starting with yesterday. Well before yesterday, if we're being honest. I know. Isn't this crazy? They have the gall to say these people aren't qualified. They're shameless. The Commonwealth is shameless. They really are. All this late disclosure, all of this, reversing the video, reversing a video, not telling us, coming up with this on the fly opinion in a witness prep session, in a pretrial interview a couple weeks before. You're going to come up with a brand new opinion that you don't disclose. And then you're going to turn around and complain about the defense. I mean, I feel Darvoed. I really do. I feel Darvoed. You're going to put Trooper Rimmer on the stand yesterday, okay, showing us how he can speak cowboy, and then you're going to complain that these enormously educated and qualified people you have to get engineering licensing. You typically have to pass tests and stuff to have that type of qualification to be able to call yourself an engineer. These guys aren't qualified enough. I mean, it is. I do. I feel Darvoed with this whole approach from the Commonwealth. But if I get a preview, I'm not really going to complain about it. Not Squirrel. I trust defense experts won't be shilling their new proprietary software and consulting biz from the witness stand. Justice for fallen father and Officer John O'Keefe. How bad was that, right? 600 global users. I mean, really seemed like he's trying to pump that up. Really did seem like a little bit like a sales session. Like how good my software program is. Yikes. Entry required. Chloe is in the Canton PD Witness Protection Program. We don't know. We don't know where Chloe is. Where did they say? Chloe's on a farm in Virginia. Isn't that what people tell their kids when they put the dog down and you don't want to tell them? Oh, it's okay. She's living on a farm in the country now, having a great life. Brian Elliman, the lack of repeatability is a problem in just about all forensic science. PCAST and the AIM studies told us that over a decade ago, but nothing has changed. Nothing has changed. Nothing has changed. The replication crisis is not limited to forensic science, too. It's everywhere. It's everywhere. It isn't even just in the social sciences, where, we kind of, I think, already appreciate these are a little bit squishy disciplines compared to, harder sciences, mathematics and physics and stuff like that. Yeah, replication is a big problem. And the only thing that's really changed is just that more people are aware of it, and more people are willing to come into court and testify about these kinds of problems. Point out things like The ballistic standards, I always harp on the ballistics because it's just the one that kills me because it's so obviously a problem. The standard for determining a match in a ballistics comparison, where you're looking at like you're looking at a gun and you're looking at a bullet or a cartridge casing or something like that, and you're trying to determine if this bullet was fired from this gun. It's the standard is something like the examiner is able to determine that there is sufficient agreement between the two. That's it. That's the standard. Sufficient agreement between the two. What the hell is sufficient? What the hell is sufficient? It's up to the examiner to decide. You've literally set a standard that's like, well, if the examiner thinks it's good enough, it's good enough. I mean, there's a lot of feature comparison techniques that are not great, and they include a lot of subjective components. Fingerprinting is one of them. Fingerprinting, though, at least gives us typically an objective standard that we can look at, X number of points of comparison. You don't even have that in ballistics. Sufficient agreement. This guy says it's good enough, therefore it's good enough. So it's just this completely self-referential standard that you can't replicate that. People have very different opinions about what is sufficient and what is not sufficient. And that's just on top of how little validation there is for any of this stuff. There have not been, broad, thorough studies where, for example, all kinds of firearms have been firearms from the same manufacturing, what's the word I'm looking for? When they put them all out at the same time, like the same run, because this stuff is mechanically produced. The whole premise is, well, there's going to be individual variations between them. You don't know that. And it doesn't even, frankly, make a lot of sense that there would be. If you are casting parts of guns, gun barrels, and then you are mechanically rifling them. No, this is not the day and age where a human being is creating that, on a forge or something and then doing this stuff by hand, where there's going to be a lot of variation. This is mechanical, this is batch production. So there's no validation for the notion that any gun in the same batch is going to be able to be distinguished from any other gun in the batch. And these things, millions and millions of guns out there. These things are produced, thousands, 10,000s every day. So yeah, these are a lot of problems. There have been a lot of problems in science. Totally agree. PCAST, the National Academy of the Sciences, was even years before that. I want to say 3 or 4 years before that, the NAS report. This has been known for a long time. And yeah, nothing's happened. I remember with the PCAST, that was an Obama administration project. And so it was continuing under his attorney general, and then Trump got elected, and then Jeff Sessions came in, and then like week 1 shut it all down. Because I think they were just about to start looking into ballistics, start doing some critiques of ballistics. Whole thing dead and gone. So it's just kind of unfortunate that that's the state of things. Not a whole lot of institutional interest in really acknowledging and addressing this problem and recognizing, yeah, people's lives are affected by this stuff. You would like it to be good, but it's just la 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 la. Kyle Murphy, does this case do harm to the whole of digital forensics at this point? I think a lot of this is a little bit, it's just a little bit catastrophic. Like this is, as I understand the dispute that's going on with this particular artifact, and how it gets interpreted and how it gets reported in the Lallybye report. I don't believe that this is going to like undermine the whole of, forensic digital analysis altogether. It's not that broad of a problem. It's a fairly narrow problem. I think the question is just going to be, are there other areas where these types of problems exist in how Lallybye exports and interprets and then reports back the meaning of the data that it finds, because that's sort of its job, is to be the interpreter for you. You've seen these cops, okay? You've seen these cops. You know that they are not getting in there and parsing out all those details for themselves. They need it to be kind of spelled out for them. And that's really, I think, the issue is Lallybye's ability to do that consistently across all of these different types of software, all of these different versions, these different devices, that type of thing. So I do think it might raise some questions about, well, are there other types of artifacts that are inaccurately reported, that are misleading when it comes up in a report? But do I really expect Lallybye to kind of take the lead on that? No, I can't say I do. I would expect it's going to be pretty much the same situation that it has been, which is that defense lawyers get their case, and of those cases, the small percentage of them that, there's a detailed investigation into this type of stuff because there isn't a rapid plea, there isn't overwhelming evidence of guilt from other sources, then in some of those they'll spot that there's a problem, and that's how problems will get identified.
Thank you. Maybe see
it's not going to be like a big
22117, the Commonwealth versus Karen Reed.
A big audit type of thing from
All right.
from
Good morning,
Lallybye.
counsel. Ms. Reed, are all of the witnesses here, Mr. Jackson?
They are, Your Honor.
I'd like to hear from Dr. Russell first. Are you both prepared to?
No, I'm so sorry, I could not hear you.
I would like to hear from Dr. Russell first.
Dr. Russell
Is that her name?
Great.
Dr. Russell, yes. The order would be, I would propose based on scheduling Dr. Russell, Dr. Wolf, Dr. Rachel.
Okay, then that's good, because that's the order I prefer. So, all right. Do
So
you
just
have
three?
a CV for her? Good morning. Morning, Tori. Do you have a CV I could look at for her, please?
Let me see if I got it in my notebook. I thought I did. Yes, I do.
And she has not written a report?
She's not.
Not written a report. They're not required to write a report.
All
I've
right, let's
talked
bring her
before
in,
about
please.
how sometimes with experts you do that on purpose.
Your
You
Honor,
don't have them
before
write a
we
report.
Get started, can I get an understanding? We started to say it at Sidebar the other day, and you said you wanted to put that off to get to the witnesses. But I need a little bit of an understanding of what the court's expectations are. My understanding of voir dire, which this seems unusual in terms of the timing of it.
So the understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation.
Is that the same with Dr. Wolf and Dr. Rachel?
Well, I thought that would help both of you. Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have a voir dire on them as well. But
So
for
that-
Dr. Russell, what we're doing here today is there's an alleged well, there appears to me to be a violation of the reciprocal discovery obligations of defense counsel regarding Dr. Russell. So let's hear from her today to see what the appropriate remedy is for this violation.
So my intention is to ask her so I have, the court understands my sort of guardrails. My intention is to ask her what her qualifications are, which is that's the basis for voir dire. And that's where I'm going to stop. I'm not intending to ask her what her opinions are, conclusions. I'm going to ask her if she's come to opinions and conclusions, but I don't want to have to examine her concerning her full opinions or full conclusions, what she's based those conclusions on. It's unfair. We've provided the defense everything that the prosecution, everything that we need to provide to them in terms of disclosure. They've got the equivalent of a report. They've got a summary of what she's going to testify to.
When was that provided? My order was 1 week from the start of trial, right?
But we didn't, Your Honor, in fairness, they didn't even finish their discovery 1 week before the start of trial. So it's a little unfair for us to be put on the same.
1 week from the filing of the certificate of compliance.
Well, I don't know when there's, I can't remember other. My co-counsel indication is the day before trial.
Okay.
So during the course of, the trial is a dynamic thing. During the course of the trial, I did not know who Dr. Marie Russell was at the time that they filed their certificate of compliance. We then attempted to, and did, give them the reciprocal discovery that we were obligated to do after they filed their certificate of compliance.
When?
Within 3 days of that. We had been giving them information prior to that, but at least within 3 days of that. We've continued, so the record's clear, we've continued to get additional discovery from the Commonwealth in notices of discovery throughout the trial. They have not finished. In fact, during the trial, they interviewed Jen McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony.
Do you need to call her again?
Your Honor, that's not my, and I think the court understands, that's not my point. My point is not, I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe.
Yeah, you have.
The point is,
I'm sorry, I missed that. You've what?
I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. The point is that what's good for the goose is good for the gander. The Commonwealth doesn't get to stand in the position of piecemealing and feeding us information, reports, discovery throughout the course of the trial. And by the way, when we then got seminal information about an expert that we did not know about, never met, never heard of, within 3 days of that, we provide everything that we have about that witness to the Commonwealth. They can't then turn around and say, oh, well, it's all the defense's fault. So we want to have a voir dire, which means that the euphemism for that voir dire is we want to have two bites at the apple.
Okay.
We want to be able to completely cross-examine her, then go back to our expert, and if she testifies, cross-examine her again after consulting with our expert. That's 2 bites at the apple, and that's not fair. If the court wants to hear whether or not Dr. Marie Russell is qualified to testify about the arm injuries, that, I believe, is the parameters, the proper parameters of the voir dire, and that's what I'm prepared to do today. But I wasn't planning on getting into the substance of her testimony because that's been provided. And I don't think Mr. Lallybye should be able to get into the substance of her testimony because he knows what the substance is because, like I said, that's been provided.
All right, so I disagree. I'm going to hear from the Commonwealth on this. So Ms. McLaughlin or Mr. Lallybye?
Your Honor, just briefly in regard to what counsel was referencing with Ms. McCabe, it was not a full interview by Lieutenant Tully. It was and I don't have it on me at this moment, but I can give the court a copy of that report. But essentially it was Ms. McCabe met with Lieutenant Tully, looked at some video, and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying, and there were no questions asked of Lieutenant Tully in regard to that. My issue, and you know, I wasn't asking for a voir dire as it proposed to, as it relates to Dr. Russell, is that we first heard of Dr. Russell on May 21st, which was, I think, 6 weeks into trial.
Right, so that's what I asked, and you told me it was 3 days after the beginning of trial, Mr. Jackson.
No, Your Honor, I said this at Sidebar the other day, and I just said it again today. I let the Commonwealth and the court know about Dr. Marie Russell 3 days after I learned about her, which was the 17th of May. I think it was the 17th of May. I had never heard of her. I didn't know who she was. We made contact. I determined that she would be useful for the jury in terms of specifically the injuries to John O'Keefe's arm. I then had one conversation with her, then immediately, within 3 days of that, turned that information over to the prosecution. So I didn't say that I gave this over 3 days into trial. That's not what I said.
All right, but you were ordered to do it. Ms. Giannetti, what was the date? What, you had 1 week from when?
The day before trial. So it would have been, I believe, April 15th. So what we knew as of that day, we were required to turn over.
All right, I need to take a quick listen.
What? All right.
Oh, Lord. So, doesn't sound great. Doesn't sound great. They just heard of her on May 21st. I mean, okay. But that's not really a great justification, because you're supposed to find that stuff out ahead of time. That is part of the deal with discovery. There's got to be a cutoff at some point. I mean, the problem is that with a case, you can be never done. It's kind of like writing a book, you know. You can be never done. We're back already. Didn't take her very long off the bench. So in that case, those were very much true rebuttal witnesses that were just responding to the specific evidence that was put out by Amber, by her testimony, and they're fact witnesses. It's a little bit different with experts. You know, you already have noticed that the Commonwealth is presenting experts, and so you're kind of on notice that if you want to respond to that, you kind of need to have your own. It's not a situation where they were just surprised, you know, by what came up.
The Commonwealth's motion, the Commonwealth's renewed motion first. Never mind, Jim.
Okay. Paper 360.
I've got it, yeah. All right, so the Commonwealth has moved that I exclude the testimony of Dr. Russell based on a violation of the reciprocal discovery obligations of the defense. So I do find that there is a violation of the reciprocal discovery obligations of Rule 14.
I don't think she's
And
going to
I'm
exclude,
quoting from the
though.
notes, the importance of this,
It's a
the
lesser-
reporter's notes to
there
the
can
old
be
rule.
lesser
And as you all
remedies.
know, we're in the process of updating that rule. But the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense. So what we're here to do today is decide a remedy for this violation. And that's why we're having a voir dire. I am not prohibiting the Commonwealth from anything on their examination of witness, Mr. Jackson. The alternative is she doesn't testify. So the Commonwealth has not
It's a great
received
trade-off.
the appropriate discovery from this witness.
We
So
get
we're
our
going to have a
preview.
voir dire, and they can ask her anything that they think they need to ask her. So those are the parameters of
I
this meeting.
understand. As long as I know the guardrails, that's fine. Just to close the loop on the record, my understanding, and this Little can probably speak to this more intelligently than I can, but during the middle of trial, there was a witness that we had never heard of, we did not know and didn't have a report for,
Who is that?
Dr. Fowler, F-A-L-L-E-R.
Okay?
If the court remembers, is buried in the middle of about 75 witnesses. So he testified to alcohol levels, et cetera, and protocols at which institution?
Yeah.
At Good Samaritan. And we didn't have that information either. We didn't throw a fit. They said we were going to provide this information in a timely fashion as soon as we know that we're going to call him. He's got to be on our witness list. We didn't know one way or the other what he was going to say. We didn't have a report, and we went on about our business. That's what we were doing as well. And by the way, I would note that the notes and the report under Rule 14 require disclosure of information you have. I just don't want the court to think that we were sitting on information that we didn't turn over.
No, I'm not saying that. It's just, this isn't as if it were something that the Commonwealth brought up and you needed to scramble. This is entirely of the defense position. So,
I understand.
all right, so that's the big difference. So why don't you go ahead and call her?
Okay. May I be excused to call her?
Yes.
That is fair. It is entirely the defense position on the dog bite stuff. I'm perfectly fine with this remedy. I'm perfectly fine with it. I mean, it's a challenge. She does have to balance the constitutional right to present a defense with the requirements of the rules, but the rules are always going to be inferior to a constitutional principle. So let him get his second bite at the apple. That's a fine remedy.
Go. Doctor, I'm just going to ask that you be mindful to step up. Remain standing, face the sworn.
Commissioner, do you solemnly swear the understood the court, the case now and here, and the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Let's take this here.
Morning.
Slide forward. Okay.
So I'm going to ask you to keep your voice up, speak right into that microphone, doctor, okay?
Yes.
Thank you. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. Good morning. Could you please state your name and spell your last name for the record?
Yes. Marie Russell, Russell.
And I'm going to echo what the court just indicated. The air conditioners are on, so please keep your voice as elevated as possible and speak. Maneuver the microphone however you need to, okay?
Okay.
Dr. Russell, what do you do for a living?
I am a retired emergency physician and forensic pathologist.
And tell me what education you have, going all the way back to the beginning, that qualifies you as an emergency physician and former pathologist before you retired.
Okay. Well, I've had about at least 16 years of formal education beyond high school. Initially, I started at MIT, where I did my pre-med courses. I had always wanted to be a physician. And so I went to MIT for a year, took pre-med courses. And then I had an unusual life event in that my mother came down with cancer, and she subsequently passed away. During the time away, so I took some time off from school. During that period of time, I decided to explore another interest of mine, which was law enforcement. And so I took some courses in law enforcement, and I became a full-time police officer here in Massachusetts.
What years were you at MIT?
That was 1972 to 1974.
Did you go to the police academy?
I did. Once I became a police officer here in Massachusetts, I attended the Boston Police Academy where I graduated.
What year was that?
That was in 1977.
During the course of your training as a police officer, did you have any specialized training in hit and run and accidents and investigations?
Yes, I did.
And which agency did you work for as a sworn peace officer?
I worked for the city of Malden full-time for 7 years.
That would be from 1977 to 1984, approximately?
Correct.
During that time, did you continue your education in any way?
I did. So Okay. I took as many courses as I could from the Massachusetts Criminal Justice Training Council, which included a course, a several-day course in hit-and-run accident investigation. I took courses in forensic photography and numerous other things. And then, and I also at the same time continued to go to college. And I did that part-time, where I eventually got a bachelor's degree of science in psychology with highest honors.
What institution was that from?
That was from Northeastern University.
And that was a Bachelor of Arts in Psychology?
I think it was a Bachelor of Science.
Got it. Subsequent to your Bachelor of Science degree from Northeastern, did you also advance your education further, formally?
Subsequent to, so yes, so I decided that I did want to pursue a medical career. And so I then attended medical school, University of Massachusetts Medical School full-time for 4 years.
Did you ultimately get a degree, an MD degree from UMass?
Yes, a Doctor of Medicine degree in 1987.
So you were there from 1983 to 1987, is that right?
That is correct.
And did you do a residency?
I did 2 residencies, actually.
Yeah,
Most people do
would.
1, but I did 2. I did.
You're in forensic.
My first residency was a combined internship and residency for 4 years, and I did that in Los Angeles at Los Angeles County Medical Center, which is a very big trauma center.
Saw some
and
stuff.
What I would consider the Bellevue of the West Coast. Very busy.
You say that just because of the volume at USC Medical Center?
That is correct.
Is it one of the busiest medical trauma centers in the country?
Yes.
You were there from 1987 to 1991, is that right?
Yes, I did my ER internship and residency during those years. Yes, there.
During that time, were you seeing patients?
Oh, yes.
You were treating patients?
Lots of them.
You were attending to patients?
I was a trainee, so I was seeing as many patients as we could. There was always a waiting room full of patients. And yeah, so I saw many patients during that time period.
Did you indicated a second residency? Tell me about that.
Okay, so I still realized I had an interest in forensics. And so I decided that I wanted to also train in forensic pathology. So I did a second residency in anatomic pathology, 2 years, followed by forensic pathology fellowship at the Los Angeles County Coroner's Office for 2 years.
And the years, if that's 4 years, that would be from 1991 to 1995 approximately?
That is correct.
Tell me what your experience was as a fellow at the Los Angeles Coroner's Office, Los Angeles County Coroner's Office.
Yes, well, it also was a very busy coroner's office.
Yes.
And so every day there would be cases. I probably did at least 2 cases a day, most days, and plus conferences and educational opportunities. But the interesting thing about being a fellow is they try to give you a wide assortment of cases. So, for instance, I not only saw numerous victims of gunshot violence and stabbings, but I saw numerous victims of motor vehicle accidents and natural death, overdoses. And then if there was an unusual case, it usually went to the fellow, because the fellow was also being supervised. So,
did any of those unusual cases, and we'll get more into this in just a second, but did any of those unusual cases include animal attacks?
Yes.
Did you become a professor, an educator at any point?
Yes. So during my 29 years at LA County Hospital, during the last 25 of those, I was a assistant professor or an instructor, but mostly an assistant professor. And what that meant is that I was responsible for overseeing the care that was provided by the interns and residents. So when a patient would come in into the hospital, the emergency room, they were oftentimes usually seen by the intern or resident, and then I would go and subsequently see that patient also. So, and that was in addition to my own cases. So I'd see my cases and their cases.
And that was at LAUSC, correct?
That is correct. And
Can I ask a quick question?
Yes.
LAUSC, for those of us who are not necessarily familiar with it, is that associated with the University of Southern California Medical Center?
Yes.
That's the school, in other words.
If she's not
Yes, so it
grifting on the
stands for
stand, why is
Los
she even
Angeles
here?
County / University of Southern California Medical Center.
And that's where you were an assistant professor for the majority of the rest of your career.
Correct.
Were you also an assistant or an adjunct professor at Cal State Los Angeles?
Yes.
Okay. For how long were you an adjunct professor there?
I believe that was 4 or 5 years. And I taught criminalistics, forensic medicine there.
As an attending physician in the ER, in other words, a supervising physician in the ER, can you tell us what some of your duties and responsibilities included, especially as it pertains to trauma? And then I'll get more specific in just a second.
Okay. Well, so I would oversee the care of all the patients that came in during a particular shift. And that would include medical patients and trauma patients. And as I mentioned, it was a very busy trauma center. So we had lots of trauma patients, including the types of violence I described earlier that I saw at the coroner's office, but lots of motor vehicle accident victims, because there was a highway there right nearby. There were a couple of highways, so a wide variety of accidents.
Did your supervision include assessing, diagnosing,
Very
and
impressive.
treating patients?
Correct.
In terms of the middle part of that, diagnosis, was part of your job to determine the cause of injuries, or to at least assess the cause of injuries?
Yes, and I took that on a little bit more because I was interested in the forensics aspect of the injuries.
The forensic aspect.
Yes.
Okay. During your time at LAUSC, even after you left the Los Angeles coroner's office as a fellow, did you continue to stay in contact with the coroner's office and have a relationship with the coroner's office as a supervising physician?
I continued to stay in contact with the coroner's office, and I used to attend their conferences as often as I could, not as a supervising physician, but as a physician and a graduate of their program.
During your tenure at LAUSC, did you ever become the director of any programs at LAUSC?
Yes.
Does that include the director of Center for Life Support Training?
Yes.
What years was that, if you remember?
I don't remember that.
The early 2000s, late 90s?
Yes, that sounds about right.
Okay.
And we would conduct lots of courses, including trauma, life support courses.
Did LAUSC incorporate a quality improvement program
Yes.
within their institution?
Yes.
Did you become a director of that as well?
Yes.
So you were director of Center for Life Support Training and director of LAUSC Medical Center Quality Improvement, is that right?
The quality improvement was for the emergency department.
All right.
Yes.
And did you also become the director for jail medical services?
Yes.
What is the association between LAUSC and the very, very expansive jail system in Los Angeles County?
So LA County Hospital was unique in that they, many, many years ago, developed a jail, what they called a jail ward, which was a combined inpatient, outpatient, and ER. So there was a dedicated jail ER. And that has been in existence for probably about 70 years now. And patients that were placed under arrest by either LA sheriffs, LAPD, California Highway Patrol, or any of the municipal agencies in the area, and I think there were about 70 or more municipal agencies, could bring their patients to the LA County jail ward where the patients would get treatment.
Ultimately, you became the director of that entire program, correct?
Yes.
Did you also work with the State Medical Board of California in any capacity?
Yes.
Tell us about that.
For about 7 years, I worked part-time for the California Medical Board as a physician assigned to one of their enforcement teams. And I did that one day a week, and I did my other job at the county hospital the other 40 hours a week.
So you didn't take off time
This woman
from your
likes to
duties
stay
as
busy.
as an ER physician, as an emergency physician. This was in addition to you being an emergency physician.
That is correct.
Did you hold the title of chief medical executive for the California State Prison System, specifically at Courtroom?
She's a
Yes.
grinder.
Tell us about that.
Oh, I respect
So
it.
I retired from LA County Hospital, and I went on to move on to the the California Department of Corrections and Rehabilitation.
And what year was that? Did you make that transition?
So 2018 is when I started for the state prison system,
Okay.
and I worked there for 5 years as director of their medical service
So you-
in Corcoran.
I'm sorry. So for that prison, within that system, you were the chief medical executive for the entire agency, correct?
That is correct.
All right.
For the entire prison.
Understood. Are you board certified in emergency medicine?
Yes,
Are you a member of the National Association of Medical Examiners?
yes,
Are you a member of the American Academy of Forensic Science?
yes.
Do you have any publications in the area? And I'm going to be very specific because you've been relatively widely published. Is that right?
Some people would say yes, some people would say no.
More than a couple of publications
Correct.
and peer-reviewed journals, correct?
Yes,
I want to focus your attention on animal injuries. Have you been published in the area of animal injuries specifically?
yes.
Do you recall those publications?
Yes, they had to do with law enforcement dog bites.
Did you
Oh,
draft an
interesting.
article or co-author an article called Managing Law Enforcement Dog Bites in the ER?
Yes, I was a co-author.
1996?
Sounds right.
And that was a peer-reviewed article,
Yes,
Wow.
ultimately published,
yes,
and ultimately available to be cited by other doctors and studied by other doctors, correct?
correct.
Did you also author or co-author an article entitled Law Enforcement Canine Dog Bites, Injuries, Complications, and Trends?
Yes, I did.
Was that in 1997?
Sounds right.
Was that also peer-reviewed?
Yes,
And that publication was also
Wow.
available for other physicians throughout California and throughout the country
She's the
to
expert on
refer
German
to
Shepherd
for the
dog
study
bites.
of animal bites and dog bites, correct?
dog bites, yes.
Dog bites. Concerning animal injuries, during the course of your professional experience, how many patients have you seen, diagnosed, and/or treated with animal injuries, including dog bites and scratches, if you had to estimate?
Many hundreds.
Would you say it's over or under 1,000?
I would say it's over 500. I don't know because we didn't keep really good records back in the earlier days.
But it's safe to say you've seen hundreds and hundreds and hundreds of dog bites and scratches.
Wow.
Yes, in my 29 years at LA County Hospital, yes. And my dog bites I took care of and dog bites that the residents took care of, yes.
And you've even published articles and studied, not just seen them, but studied dog bites and dog wounds, correct?
Yes,
Wow.
Have you qualified as an expert previously in other courts as in emergency medicine?
yes,
Have you qualified as an expert in other courts in forensic pathology and wounds?
yes,
Has that been in both state and federal court?
yes.
Doctor, were you asked to review certain materials related to this case?
Yes,
And that was in furtherance of coming to, if you could, come to an opinion or a conclusion about injuries to the victim in this case, a person by the name of John O'Keefe.
yes.
What did you review in anticipation of your determining whether or not you could come to an opinion or a conclusion?
So I reviewed hospital photographs, autopsy photographs, an autopsy report, grand jury testimony from the medical examiner in this case. There may be some other,
Based on,
I just want to ask about that. Do you have notes with you as to what you reviewed?
no.
Okay, so when you say there might be other, you don't,
Well, if
if he tells you what you reviewed, you'd know it?
I would recognize it.
All right, but I want to hear it from you.
Oh,
You
I see.
don't know of anything else that you've reviewed? This is sort of important, Mr. Jackson.
Okay.
Can you think of
Would it
anything else,
refresh your
Dr.
recollection?
Becerra?
Autopsy photographs, autopsy report, neuropathology report, toxicology report, and the grand jury testimony.
The
Okay,
DNA
so
results?
as you recall, the items that you reviewed include an autopsy report by Dr. Scortibello, correct?
Yes,
A neuropathology report by a doctor named Stonebridge, correct?
yes,
Toxicological reports associated with the autopsy,
yes,
grand jury transcripts from Dr. Scortibello,
yes.
photographs of evidence items, including a gray sweatshirt,
Oh, yes, yes,
and autopsy photos that were taken attendant to the actual autopsy.
yes, and photographs that were taken in the hospital, and I reviewed the hospital ER record also.
So in addition to what you just listed, there's also hospital photos separate and apart from the autopsy photos, is that correct?
Yes,
And those hospital photos showed the injuries to Mr. O'Keefe's arm, is that right?
yes,
And you also reviewed emergency room records that are attendant to his initial acceptance into the emergency room on January 29th, 2022, correct?
that's correct.
Based on your review of all of those materials, were you able to confidently come to any conclusions or opinions about the nature of the injuries suffered by John O'Keefe, specifically as they relate to John O'Keefe's right arm?
Yes.
What is your opinion and conclusion concerning those injuries?
Those injuries appear to be consistent with an animal attack.
Can you be more specific in terms of the type of animal, or are you relegated to simply an animal attack?
Well, they are consistent with a large dog attack. There's a combination of both what I consider bite wounds and scratch wounds on the arm. There were also some puncture wounds in that shirt.
And are the
So I'm sorry, puncture wounds in the shirt?
Puncture holes
Okay.
in the shirt.
and on what do you
Don't act
base the
confused,
opinion
Judge.
that the injuries are consistent with dog bite or scratch marks?
Well, the patterns. There are several patterns of parallel wounds that appear to be superficial scratches that could have been caused by nails or could have been caused by teeth. There are different angles on the arm and different locations on the arm, and but they're generally oriented in a specific direction. And there's also an area, the distal forearm, which is close to the wrist, which shows what I believe is an arch area of teeth marks.
And what's the significance of the arch area?
Well, so the arch would be the front area of the jaw of the animal, you know, or the dog in this case, where the teeth tend to be close together and curved. There's a curved pattern to the configuration of the teeth.
Let me have just a moment, Your Honor.
Yes.
Large animal, large dog. Like how large of a dog? Like a German Shepherd dog sized dog? Like a former police dog kind of dog? Such a small audience in there today, even the press.
Doctor, I'm showing you a series of photographs. May I approach, Your Honor?
Yes.
First, can you describe whether or not you recognize what's depicted in that photograph? Have you seen that photograph before?
Yes, I have.
Is that part of what you reviewed in coming to your opinions and conclusions?
Yes.
What is that a photograph of?
So this is a photograph of the decedent's arm near the elbow. And do you want me to describe what it shows?
Just briefly.
Okay.
Of what
Yeah, and it shows wounds.
Okay. Your Honor, I would ask that that be marked as next in order of evidence.
All right, so for this voir dire, we'll have separate evidence, right? Is this an exhibit number in the trial already?
It has not been marked yet, so I'm fine with starting over, sort of for the purposes of what your process are.
So this will be a separate voir dire with separate exhibit, yes.
So it's going to be exhibit 1?
Yes.
Aha. Well, that explains it. Thank you. Makes sense.
Your Honor, I want to move this along. This has been marked, but I think.
Hold on. Okay.
I'm so sorry. This one of the three has already been marked, but if, just for consistency, I'd rather mark it additionally for voir dire. Yes.
Need a separate
Okay.
record for the voir dire.
May I approach?
Yes.
This one's already been marked, but I'll remark it.
And if you'd tell me the exhibit numbers that they are. So you're putting these in now? There's no objection, Mr. Lally?
For purposes of this, no.
Okay. So we'll mark these now, but
May I approach?
yes.
One.
It's making this
The one
tough
with the
in
label
terms of what
285
the
on the
appropriate
bottom
remedy
has
is here.
previously been marked in the trial. I would ask that this be
There
marked
is
as the next in order
some
for the
case
voir
law.
dire.
But what I want is the exhibit number at the trial.
It's right there in what the Commonwealth cited, that when it's really material to the issues presented in the defense, you kind of have to give way on the discovery rules and timelines.
Okay?
This seems pretty central to the defense theory. And by the way, it's direct evidence of third-party culprit.
Is that 19? That's correct. It's 19.
Okay? And is the third one also in evidence, you said?
2 of the 3 have not been marked.
Yes, voir
as soon as
dire
that
is
report
absolutely
ready.
included
She's
in the
ready.
appellate process. That's why we're
May
doing
I
it on the
just
record
establish
here.
foundation?
Yes.
Because
The
if she
following
rules
2
to
photographs
exclude
that I just
this,
showed you, Doctor, do you
definitely
recognize
appealable.
those?
Yes.
Did you also review those in terms of, in furtherance of coming to your opinions and conclusions?
Yes.
Do they also appear to be different photographs of John O'Keefe's arm?
Yes.
I would move for the admission of both of those, Your Honor, for purposes of voir dire.
There's been no objection to them, so they're in. They're already marked.
I just need to know which one's 2 and which one's 3. May I approach?
Yes.
Judge is being quite short this morning, isn't she? Yeah, she knows. She knows this is very good for the defense.
With court permission, may I publish
Yes.
Exhibit 2 for voir dire?
Yes.
Kind of hard to say for sure, but
Is this a photograph of of John O'Keefe's arm?
the case law in the
Yes.
This is one of
Commonwealth's
the several
brief
photographs that
would
you,
suggest, yeah,
reviewed
big
in coming
problem.
to your opinions and conclusions.
This is very
Yes.
I
material
want
to the
to ask you a
defense.
couple of questions about this. There should be a laser pointer on the desk.
Remedies can be recess
Can you explain for the jurors what it
for the
is about
Commonwealth
the
to
injuries that
respond.
assisted you in coming to your opinion and conclusion that this is from an animal attack?
Okay, there's several patterns here. So for instance, let's look here, right near the elbow, the exterior part of the elbow. There's these 2 linear marks, which appear to be from upper teeth, and 2 punctures below those, which are superficial meaning they didn't go very deep into the skin, but they appear from the lower teeth. So that's one pattern. There's another pattern close to the shoulder, which shows parallel marks, these two, and maybe a third one in the middle, parallel marks that are oriented at a certain angle. And these are superficial wounds, which are consistent with teeth marks. They also could be possibly consistent with nail marks, but
With what?
nails from claw, yes.
All right.
We have some more here, similar from obviously different teeth involved or different claws, and then down here, closer to the wrist, we have an unusual pattern of at least 4 striations, the way I see it, at least 4 striations that I believe are caused from the teeth towards the front of the mouth, near the arch. It appears that there's an arch pattern here. So,
In a dog attack or in an animal attack, in your experience, and we can take this one down. Let's cover the ground on the 3 exhibits that we've already marked. Can we take a look at exhibit 1? Is this just may I publish, Your Honor? Yes. I apologize. Is this just a close-up of the same injuries?
yes,
And do these appear to be consistent with what you just testified to in terms of either teeth or claw marks, especially as it
Those look
relates
like
to
top
the
and
area
bottom.
closest to the elbow?
yes,
All right. And then looking at exhibit 3. May I publish?
Yes.
Is this a close-up view of the area closer to the wrist that indicated those parallel, you used the word striations?
yes,
All right, and these appear to be taken, attended to the autopsy as opposed to the other photograph, exhibit 2, that was taken in the hospital. Is that right?
that is correct.
All right. And would the time difference account for the slight change in the nature of the wound?
It could,
Photograph of the wound, I guess?
it could, or a different technique, yes.
Okay. Let me take these down. Did you take into consideration the lack, in coming to your opinion and conclusion, the lack of other injuries, for instance, fractures, broken bones, or deep bruising, soft tissue injuries?
Oh, yes.
How did that play into your opinion?
Well, coming to my conclusion, and so I wanted to rule out other things, and there were no significant major bodily injuries outside the head. There was nothing. There were no fractures of the long bones, the chest, the pelvis, the arms. So yeah. So having seen hundreds and hundreds of car accident victims and people hit by cars, I ruled that out very quickly.
Okay.
Very
And
quickly.
in terms of the injuries that you did see, especially as they're attended to the arm, based on everything that we've discussed today, is it your opinion, based on a reasonable degree of scientific certainty, that those injuries are consistent with an animal attack as opposed to a motor vehicular pedestrian incident?
Yes.
Thank you. That's all I have.
All right, Mr. Lally.
Good morning, ma'am.
Good morning.
Let me take you back to, you were talking about some police training that you had received when you were in the academy or while you were working with the police department here in Massachusetts. Is that right?
Yes.
Okay, what kind of training what did that training consist of?
Well, I
Going back to the
attended and
training
graduated
now?
from the standard
Because
police academy at that time.
MVA is bad.
And then I
Ruled
took
it out
additional
very
courses that
quickly.
were offered from the Massachusetts Criminal Justice Training Council. And these were taught generally by experts in their fields, and they were on a variety of subjects that are listed in, in my CV, included, the hit and run accident investigation, forensic.
There, just for a minute, ma'am. Doctor, in reference to your training as it pertains to hit and run accidents, what did that training consist of?
Oh, well, mechanisms of how accidents occur, mechanisms of how to determine, what vehicle was involved in an accident. I don't, it was a long, long time ago, but yeah, so determining if people were struck by vehicles, what vehicle was involved, or if there was auto versus auto accident, what vehicles were involved.
And I don't mean to belittle this training whatsoever, but is it fair to say that that was relatively rudimentary training that you received in the academy?
Yeah, kind of like your expert got, Lally.
Probably, I would not, yes, okay, probably. If
You don't have any training in crash reconstruction or anything like that, correct?
that is correct.
And am I correct in you indicated that you're board certified in emergency medicine, is that right?
That's correct.
And so you're not board certified in forensic pathology or anatomical pathology or any kind of pathology?
That's correct.
And the last time that you worked as a coroner, when was that?
Last time was in 1995 when I was doing autopsies for the coroner's office. I have since, though, consulted on some cases from the LA coroner's office.
What, about 30 years ago? Is that about right?
For autopsy, yes.
Now, have you ever testified in a case in which either Mr. Jackson or Attorney Little were counsel?
Not that I'm aware of, no.
And when was it that you first were contacted in reference to this case?
The first contact was May 15th.
May 15th of what year?
May 17th, excuse me, of this year, 2024. Yes.
And you went through a list of things that you were provided and you reviewed, and you mentioned hospital photos, correct?
Yes.
Autopsy photos, is that correct?
Yes.
An autopsy report, is that correct?
Yes.
Grand jury testimony from the medical examiner, is that correct?
Yes.
A neuropathology report, is that correct?
Yes.
A toxicology report, is that correct?
Yes.
And then I think you also remembered some photos of some clothing items, is that correct as well?
Yes, a shirt. And
Anything else?
yeah, hospital ER record.
Hospital ER records?
Yeah, yes.
Anything else that you can think of?
No.
Did you ask for anything else to review?
No.
Were you told of any other material that was available for your review that you weren't then given?
Well, I requested that that I focus in on the wounds, so I didn't ask for a lot of material in this case.
But fair to say that you were looking for anything and everything, material to the wounds that you were asked to look at, correct?
Please say that again.
Sure. Fair to say that you would want to look at anything and everything that was related to the wounds that you were asked to look at, correct?
Yes.
And so, did you make any specific requests as to what material you were provided, or were you just handed some material or forwarded some material and you looked at what you were given?
No, I requested that I have the autopsy photographs, the ER records, the ER photographs. I requested those.
Now, you mentioned some articles that you had written that were published back in 1996 and 1997 related to dog bites, is that right?
Yes.
Are those publicly available articles?
Yes.
And in those articles that you wrote, you were talking about law enforcement bites, correct?
Yes.
So law enforcement canine bites typically involve what you call sort of a bite and hold technique, is that correct?
Yes. Yes.
So is there a difference between, through your experience and the hundreds of dog bites that you've seen, is there a difference between what you would observe from a dog bite from a law enforcement canine versus just your domesticated dog?
Well, yes. Now, the study, one of those studies was over 700 dog bite wounds, and there were two techniques used at that time: bite and hold, and later on, bark and hold, or bark and alert, or something of that nature. So there are different techniques, but yes, to specifically answer that question, which was, are they generally different from regular domestic dog bites? Yes.
Now, did you write a report in regard to your opinion that you testified to here today?
No.
Why not?
I don't think there was much time, and I didn't know
Yeah.
if I was going to be actually testifying.
How long would it take you to write a report?
I wasn't asked to write a report, excuse me.
Were you asked specifically not to write a report?
No.
Now, at any point in time, did you ever look at anything related to Mr. O'Keefe's head injury?
Oh, yes.
So you reviewed reports in relation to that, correct?
Yes.
Do you have any opinions as it pertains to that?
I would rather defer to the pathologist and neuropathologist on that.
So who contacted you about this case?
I contacted a district attorney that I had worked with in the past. We were discussing a different case, a case that I autopsied in 1995. And I mentioned that I heard that there was a case in Massachusetts that might have been being handled by one of his colleagues, his former colleagues, and that there was an issue of whether something was a dog bite, and that I might be able to help in that case, to clarify.
And so when you were provided this material, what is it that you were specifically asked to do?
To look at the wounds and the reports and the materials that were sent to me and render an opinion.
And so before you had even been provided any material, before you had even looked at anything, you had already heard information related to there being a dog bite involved in this case, correct?
I had heard that there was a controversy, that there's some certain wounds could have been a dog bite versus perhaps inflicted by a motor vehicle. That's what I had heard.
So what I'm really trying to get at, Doctor, is sort of the timeline. Okay, so you hear about this, when was that?
Sometime just before May 17th.
So sometime just prior to that, you hear about some controversy in a case in Massachusetts involving a dog bite. On May 17th, you get reached out to by who specifically?
His name is John Lewin. He's an attorney in the LA District Attorney's Office.
And then who did you talk to after that?
I reached out to him. I said I might be able to clarify. And then he reached out to Mr. Jackson, I believe, and then Mr. Jackson contacted me.
And not asking specifically anything you spoke about, but at some point, the discussion came specifically to dog bites, correct?
He sent me the materials. He asked me my opinion.
Mentioned the materials, asked you your opinion. When did you provide that opinion?
Probably the next day. Yes, I know it was the next day.
So the very next day, on May 18th, you provided an opinion?
Yes,
And was that opinion provided in a written fashion, orally? How was that provided?
orally.
So you reached out to someone shortly before May 17th, spoke to Mr. Jackson on the 17th, received all the material, and then had an opinion by May 18th.
Yes.
But you didn't write any of that down.
No.
Now, beyond the materials that you were provided, what else were you told about the case?
I was told that the victim was a police officer. The decedent is a police officer. I was told that well, the defendant had been charged, and I was told that that there was a controversy about whether or not these injuries had been caused by a motor vehicle. And I was also told, and I read in the medical record, that the decedent was found outdoors, I believe in the snow, and hypothermic.
Now, in regard to what you reviewed, you didn't review any investigative reports, is that correct?
That is correct.
You didn't review any witness statements, is that correct?
That's correct.
You didn't review any lab reports as far as from the forensic lab or anything like that?
I reviewed the toxicology report.
Beyond that, any other?
If it was part of the autopsy report, I reviewed it.
You reviewed everything attended to the medical examiner's file, is that correct?
Yes.
Nothing from the lab beyond that?
I don't believe I did.
Now, this first instance when you say you heard about it, how did you hear about it?
Well, I believe it was via a headline that I received in my email from the from Boston Globe headline. You know, it was some kind of there was some kind of interesting case, and I got it as an email, and I looked into it.
And when was that?
Well, that was that week in May, that, just a few days before May 17th.
You subscribed to the Boston Globe online?
I did at that time. I have not renewed it.
How long had you been a subscriber to the Boston Globe?
I'm going to allow it.
Probably a year or 6 months, 6 months to a year.
There was never any headlines or anything else that you saw about this prior to that week just before May 17th?
Not that I paid attention to.
I have nothing further.
Anything further, Mr. Jackson?
Nothing further.
All right, so since this is a voir dire, I get to ask questions, Doctor? So
Oh, yes,
I
okay.
just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion?
Yes.
To what
These
degree?
injuries in the arm are, my opinion is that they are the result of animal bites or scratches.
And do you know what kind of animal?
Oh, yes, most likely dog, large dog. And I'm very reasonable, very sure to, what's the word I want? Medical certainty, very
right, so
high degree of medical certainty.
Reasonable degree of medical certainty.
Yes,
Well, she said
definitely.
high. You said reasonable.
Okay, and another question. So I received information that you also viewed all reports associated with Chloe, a dog's prior bite history. Did you review those?
No, I don't recall ever seeing anything like that.
That you also reviewed the UC Davis DNA testing results submission forms?
No, I don't recall seeing them.
Okay, any follow-up, any questions based on my questions?
Not for the Commonwealth, no.
No, Your Honor.
All right, you are all set, Doctor. I don't know yet whether you'll be testifying.
Okay.
We'll try and let you know. You're going to be around in a few days?
No.
Okay, we'll let you know as soon as we can, okay?
Okay. Okay.
Thank
All right. Thank you.
That look with a reasonable degree of medical certainty. That's your bullshit language, Judge. That's your language. It is not scientific language. Reasonable degree of certainty. That's legal mumbo jumbo. She said, I'm very sure. Very sure. So are we going to argue that now, Judge, or are we just going to go on to the next witness? The problem is this is absolutely central to the case. There's no showing of bad
So
faith
I would
by
like
the
to hear
defense.
argument on this witness before we hear the other witnesses. So And Ms. Giannetti, I asked you the other day whether she reached out to you or you reached out to her, and you said there was an intermediary. But my concern was whether she came out of nowhere and reached out about this case, and that seems to sort of...
It wasn't Mr. Giannetti, it was me.
Okay. All right. So the question I asked was answered pretty much by this witness, whether she
She
saw
saw it on the
something
news
and
and came
decided she
forward.
wanted to come forward.
And that explains
All right.
the late
It's a
disclosure.
Commonwealth's motion. What are you asking me to do? Again, I found a violation of Rule 14. And there are two concerns here, the competency of the witness's testimony, how much she can testify to, whether she should testify at all. What is it you're asking me, Mr. Lally?
Your Honor, I'm asking that the witness be excluded from testifying at the trial for the violation of Rule 14, specifically, I believe it's Rule 14A6. This is a witness, as the court picked up on, that reached out, albeit
Jackson,
through an
be prepared
intermediary,
to argue the case law standard here. He has
with
done kind
reference
of a poor
to just
job
sort
of
of
that.
discovering or coming upon
so
this
far.
case in several weeks into the trial. It is concerning, given the fact that the witness represented that she had a subscription to the Globe Online, received word of this, and the first time that she had ever seen it or it had grabbed her attention was in that first week of May, when, as the court is well aware, there's been widespread media coverage, particularly through the Boston Globe, for years at this point. The limitations of the testimony, it's also concerning because the disclosure from counsel indicated, again, as the court had noted, I didn't want to get into too much as far as for purposes of this voir dire, but there was additional material that was indicated in the disclosure that the witness had reviewed, including the UC Davis related to the canine DNA or the lack thereof, as well as, forgive me, the dog bite history of that specific dog, which also, I would note for the court, includes photographs of what a dog bite from that specific dog looks like. And that specifically apparently was not provided to this witness, who's then opining on, inferably at least, that that dog was the cause of these particular injuries. However, was not shown specifically anything to do with that bite history as far as by way of reports or photographs. So that juxtaposed or coupled with the immensely late disclosure. I mean, we're talking about at least the 6th week of trial by the time this witness is even mentioned, not on the defendant's witness list, not mentioned at any point in time during the pendency of the case, and then sort of pops up in the middle of May.
If it's not bad
and
faith by
to the
the
point
defense, then that doesn't
the
matter.
limited amount of material or information that's provided by counsel as far as disclosure opinion doesn't come until today. So for all those reasons, Your Honor, the Commonwealth is requesting that her testimony in its entirety be excluded from this trial.
Jackson?
Your Honor, exclusion is the highest form of punishment. It's the highest form of sanction the
Yep.
court has available to it. Just to put a fine point on it, it is a dire remedy. And I know the court has mentioned 2 or 3 times, I'm finding a violation of Rule 14. That sounds as if the court is suggesting or has inferred that we did something wrong. We didn't do anything wrong. Because the court learned, I didn't reach out to her. She reached out and said, hey, look, I've got some experience with this.
I asked you that the other day, though, and I was told that you reached out to her through an intermediary. I wasn't
No.
told she reached out to you through an intermediary.
I don't know that there's a difference. I mean,
What I was trying to get at, is this somebody who read about this case and said, you know, I want to be part of that? That's what I was trying to get at. I
Well,
think it was
that's what
pretty
she
clear,
said,
Mr.
isn't
Jackson.
it?
Go ahead, continue with your argument.
okay, I did not misrepresent anything.
I didn't say that.
I take offense at the court's tone that yes, you did say that. You just said that. You said,
Okay.
I just heard the testimony, and it's not what I said the other day. I know a person in Los Angeles DA's office. I received a text message from that person saying there's someone who reached out to me who said I might be able to elucidate
So then he called her.
controversy concerning the dog bites. I then reached out to her. So when you asked me who reached out to whom, I reached out to her through an intermediary, my friend in the DA's office back in Los Angeles County.
So maybe it wasn't clear what I was looking for. I think it
Yes,
was
maybe it
clear.
wasn't,
Go
Judge.
ahead, continue with your argument on this.
My point is, Rule 14 requires a sanction if in fact the attorney has done something wrong. In other words, it connotes the idea that we're doing something by actively hiding evidence or holding
Right
back
to present a
evidence,
defense,
or not
Jackson.
providing
Go
evidence
there.
that you know you're going to use at some point in an effort to take a tactical advantage. And the sanction for that is exclusion. I've never met this woman. First time I laid eyes on her was during the process after she flew out here to engage this voir dire process. She indicated I could potentially provide some information about this controversy concerning dog bites. I then sent her materials. I talked to her. I sent her materials. I found her to be incredibly credible. I found her to be experienced, and I found her to be knowledgeable in this very specific area, which is rare. There's not that many people who have published, doctors who have published in the area of dog bites specifically. So I thought it makes sense for me to reach out to her and talk to her, which is exactly what we did. And within a couple of days, literally, you could almost count it by the hours of me receiving her information, we then had a discussion amongst ourselves. Is this somebody that we want to then present on the defense side, on the defense case, and we turned the information over to Mr. Lallybye. I understand that it was well into the trial, but that's not a fault of ours, and I don't think the sanction of exclusion is necessary or appropriate to punish Ms. Reed from having an experienced witness testify in rebuttal to ultimately what Dr. Scortibello and the Commonwealth is going to present in their case in chief. That's what she's going to do. She's going to present contrary evidence or an alternative theory of where those injuries came from to a person. Everybody on the Commonwealth side who can elucidate about this has said those injuries come from a tail light, including Mr. Paul yesterday. We have contrary evidence, and Ms. Reed should be entitled to present that evidence, even though it came late. It didn't come late by any fault of ours, and I don't believe that the Commonwealth has made out a prejudice that they can't overcome. It's late. Obviously, Mr. Lally is a skilled lawyer. There's nothing to say that he can't or hasn't been able to prepare for the cross-examination or for an examination in front of the jury. And I just don't think exclusion is appropriate.
All right, so the second part of this argument, and I'll start with the Commonwealth first. So in your motion to exclude, you also raised Daubert-type concerns. So, Mr. Lally, is there portions, if I permit her to testify, are there portions, focus specifically on the part of her opinion where she says, I guess the defense expects her to be able to say she will testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. I think you have an uphill battle on that part, Mr. Jackson. The Commonwealth, what are you saying? If she testifies, what should she be able to testify to? And don't just say nothing. I want some input.
Isn't
No,
the
if the
for
court were
someone going to
permitted to
testify to the
the doctor
opposite?
to testify, Your Honor, what I would submit would be permissible testimony from a legal standpoint as some factual questions in regard to that. But from a legal standpoint, I think the court could permit her to testify as to the injuries that she observed, her work in history in that area, observing prior injuries related to animal attacks and whatever consistency she believes that they have with that. I do not think it would be proper to allow this witness to testify or opine anything about the inconsistency with regard to pedestrian injuries. I don't think any proper foundation has been laid for there, whether it be through experiential knowledge in relation to that, or any sort of specialized training or knowledge or anything to do with that. Anything from a forensic pathology or anatomical pathology perspective, I think should also be out of bounds and excluded with regard to this witness. She's certainly a very experienced emergency room physician. So anything in relation to that, I think it's permissible, but
All
as
the
far
MVAs
as
she's
the,
treated?
experience when it comes to motor vehicle crashes or pedestrian crashes, of which the court is well aware, there are a litany of different types of interactions a pedestrian can have with a motor vehicle in a collision sequence. And simply saying, well, there was no injuries to the leg, so it couldn't have been a motor vehicle collision is just plain wrong.
That's not what she said.
And not backed up by science or anything else
All of the long
that this
bones.
witness can testify to from the very limited experience she has in that realm. So if the witness were able or permitted by the court to testify, I would submit that her testimony should be relegated to simply what, if any, opinions, her experience, obviously, and then what, if any, opinions she draws with regard to the causation of the injuries on the right arm, as it pertains to consistency there. But I venture to guess that it's likely that those are probably also going to be, in her opinion, consistent with many other causes beyond that, if she's being reasonable.
All right, Mr. Jackson?
I'll submit, Your Honor. I have no issue with, I just said I'll submit, I'm not submitting. I have no issue.
Because he's got other experts
limiting
that will
the
say that.
testimony to the animal attack issue, the dog attack issue. I didn't, as the court noted, I didn't spend any time. I think I may have asked one question consistent with the motor vehicle incident. I have no problem if the court wants to limit her testimony to the dog bite aspect and not the motor vehicle aspect. I wasn't planning on going into that aspect anyway. I've got another pathologist who's going to do exactly that.
But you did go through it with her, and it's on your disclosure.
It is, but I have no problem editing.
So why is it on the disclosure or where the Commonwealth turned
Because
over
he
that she
proffered
viewed
it,
all
Judge.
reports associated with Chloe's bite history in the UC Davis DNA testing? Why is that in there?
Because we sit that in a Dropbox. We sit everything in a Dropbox, and I assumed that she reviewed it. She must not have seen it or opened it or reviewed it. I didn't know. But that's what was sent to her. Everything that's in the disclosure is what was sent to her.
All right, if she's permitted to testify, you led her through quite a bit today. You won't be able to. I mean, she struggled with to what degree of certainty she held an opinion. She struggled
didn't,
to
Judge.
what she viewed.
You didn't like her words.
She didn't write a report. I have to consider all of these things too, as the gatekeeper as to whether she can actually assist the jury. So I'm not deciding this right here. Mr. Lally, if I do permit her to testify, I will give you time to absorb this testimony and to find an expert in rebuttal for this. How long might something like that take?
Not terribly long, Your Honor. As far as preparation, I can't give an exact time frame on that. As far as a rebuttal witness, I'd say a week at the most.
A week from today?
Yes.
Why don't you start looking at least? All right, well, I decide I won't know until Thursday.
Sure.
All right. All right, anything else on this witness?
Submitted, Your Honor.
All right, next witness, please.
With regard to Dr. Wolf and Dr. Rentschler, this is a different scenario, and I'm presuming that the court is asking for a what year on their qualifications.
Well, I want to know who did what. I want to know, they say we. I want to know who did what.
So is the court suggesting that I go through their entire testimony of exactly what they did, their testing, their opinions, conclusions, the bases of their opinions, conclusions?
However you want to do it, Mr. Jackson, we're here today on the Commonwealth's motion.
I realize that.
So they
That's
usually
not
go
the
first
Commonwealth's motion to
because of that?
depose our experts. The Commonwealth's motion is they're not qualified as accident reconstructionists. I don't need to go, and I'm not inclined to give them a free bite at the apple to cross-examine these witnesses twice on the basis of their opinion. I will go through, I think, to the court's satisfaction. I don't think it's going to take long to figure out that they're extraordinarily qualified to render opinions, but I don't think it's incumbent upon me to walk through their entire testimony and give the Commonwealth a free bite at the apple like it's a deposition.
Whatever you want to do. I'm not telling you what to do. Whatever you want to do.
No, she only tells Lally what to do. Mr. Lally, focus on this thing. Unbelievable. Unbelievable. So he'll limit it now to exactly what she said she wanted to hear, right? Qualifications and who did what, and then she'll complain about other stuff he didn't get into. When it's the Commonwealth who goes first on the Commonwealth's motion. You got a question? Why don't you have the Commonwealth ask them what their questions are? You have Mr. Jackson over here mind read what the Commonwealth's problem
Someone
is.
ever give the court the case now and here and should the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Just speak very loudly into the microphone.
Whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolfe, last name spelled W-O-L-F-E.
So what do you do for a living?
I am the director of accident reconstruction at a company known as ARCA,
Director of
A-R-C-C-A.
Accident
And tell us a little
Reconstruction.
bit about ARCA. If you could explain to the court what ARCA is and what its primary mission is.
So ARCA is a forensic consulting engineering company. We have a variety of disciplines that include biomechanics, failure analysis, human factors, premise liability, crashworthiness, and accident reconstruction.
You said that you were the current director of accident reconstruction, correct?
That is correct.
Is that a specialty of ARCA specifically?
Yes, sir.
And what sort of contracts does ARCA routinely engage in?
We typically work for law firms, insurance carriers.
What about other clientele? For instance, maybe it's an insurance carrier or a law firm, but what about the ultimate client, the military, Department of Defense? Have you contracted with other entities or agencies, sporting agencies?
Certainly, yes. We've done research for the military. We do player safety for the NHL. So yes, we are involved in a number of research projects as well.
And in terms of ARCA and its commissions and consultation, is it known both nationally and internationally? Is it recognized as a leader in the area of accident reconstruction?
Yes.
As the director of accident reconstruction, do you specialize in not only accident reconstruction, but human factors as well?
Yes, sir.
Can you give me a synopsis of the professional discipline of accident reconstruction? What is accident reconstruction?
Well, I think that's a very broad topic. I look at the cases that come across my desk. You know, I've been involved with pedestrian impacts, and that could be pedestrians hitting the side of vehicles, fronts, backs, getting run over by vehicles, being struck by a vehicle, then projected into another vehicle. I've dealt with your simple fender bender collisions. I've dealt with collisions that involve 60-car pileups on a highway. So again, accident reconstruction in terms of the scope for a case, it can really vary case to case depending on the facts and circumstances of that case.
And when you say dealt with, are you talking about literally going into, from an engineering and a scientific standpoint, trying to reconstruct what happened, what the causal effects were of that accident, and what the results were, the resultant damage or injuries were?
Absolutely.
What about human factors? What does that discipline entail? What is human factors?
Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian's coming out into the roadway at night. Maybe it's not a lit roadway and you're relying on your vehicle headlights to illuminate that pedestrian. So it's determining when would a driver recognize that individual on the roadway based upon the headlights, if there is any artificial lighting, their clothing. And then we look at how do drivers respond based upon that scenario that they're presented with. So we know that response times are different depending on the hazard that's presented to them. So if it's a pedestrian coming to the roadway, it's a vehicle stopping in front of you. So that's the application of human factors.
And that might include everything from passenger vehicles, commercial vehicles, bicycle issues, motorcycle issues, things of that nature.
Yes, sir.
Okay. What education, training, and background qualifies you to perform the duties that you've just described as director of accident reconstruction at ARCA?
In terms of my educational background, I received a Bachelor of Science in Engineering from James Madison University back in 2012, along with a minor in mathematics. Some of my coursework while at James Madison included courses in physics, statics, dynamics, kinematics, material science, and your typical engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
Did your research area also include physics, in addition to electromagnetics,
Yes, sir.
optics,
Yes, sir.
photonics,
Yes, sir.
and lighting?
Correct.
Are you accredited as a traffic accident reconstructionist?
Yes, sir.
By whom?
By an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstructionists.
Are you trained in photogrammetry to determine vehicle crash and map scene evidence from photographs?
Yes, sir.
In other words, looking at a photograph rather than being at the scene, that is a specialty or a specific area of training that you've engaged, correct?
Yes, sir.
Are you trained in Bosch crash data retrieval analysis,
Yes, sir.
otherwise known as CDR analysis, right?
Correct.
In terms of professional associations and accreditations, are you certified by the Society of Automotive Engineers?
Yes, I'm a member of that organization.
What about being a member of Optical Society of America,
Yes, sir.
Illuminating Engineering Society,
Yes, sir.
and finally, the National Association of Professional Accident Reconstruction Specialists?
Yes, sir.
You're accredited by all of those organizations, is that right?
I'm a member of all of those. Yes, sir.
Have you authored peer-reviewed articles in the area that we've just discussed?
I've authored a number of papers in the field of physics, and one of my most recent publications was that dealing with Toyota and Lexus vehicle control history records.
In 2021, did you author or co-author a peer-reviewed article known as Collision, the International Compendium for Crash Research Dealing with Vehicle Control History and Braking Issues?
Yes, sir.
Have you qualified in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, when you walked into court, have you and I ever met face to face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCA, with the responsibility of doing an accident reconstruction in this case, correct?
Correct.
Person to my left, the female to my left sitting here, you ever seen her before?
Nope.
Do you know who she is?
Yes.
Know who she is. Never seen her before.
How many times have you been qualified in other courts to testify as an expert in the area of accident reconstruction?
I think it's around 20 times to date.
In both federal and state court?
Just state court.
Multiple states?
Yes, sir.
Your analysis, conclusions, and opinions are completely independent, whatever they are. Those analysis, conclusions, and opinions in this case are completely independent of the defense and of the Commonwealth. Have I got that right?
It's based on the evidence. That's correct.
And you're not paid by either side here in this courtroom?
Correct.
You and your team were asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court. Is that right?
That's correct.
Who at ARCA was assigned to the team who ultimately would undertake that analysis?
So it was myself, Dr. Andrew Rentschler, and Scott Klein.
Scott Klein has a Master of Science, is that right?
I believe he's got a Bachelor of Science in Mechanical Engineering, yes.
In engineering?
Correct.
All right. And Dr. Rentschler is a PhD in what area?
Biomechanical Engineering.
Were you provided and did you review certain materials in furtherance of your consultation in this matter?
Yes, sir.
I can have just a moment, Your Honor.
Yes.
I'd like to use my time efficiently, Doctor. I'm going to read through a number of materials that you reviewed. Before I do that, may I approach, Your Honor?
Yes.
I just want you to take a look at the first 2 pages of that document and tell me if you recognize that.
Yes, sir.
What is that? What are those 2 pages?
These are the first 2 pages from the report that ARCA issued in regards to this matter.
Do you see a list of 14 items on those 2 pages?
Yes, sir.
Is that an accurate reflection of the items that you were provided by this other agency to review in terms of coming to your opinions and conclusions concerning this case?
Yes, sir.
May I approach, Your Honor?
Yes.
Those items include the Norfolk SPDU homicide death report, correct?
Correct.
The Commonwealth of Massachusetts Department of State Police crime scene report, correct?
Correct.
The OCME dispatch removal report, correct?
Correct.
Photographs of the incident location,
Correct.
videos of the incident location,
Correct.
photographs of the 2021 Lexus LX 570,
That's what
Correct.
we understand.
photographs of recovered evidence,
Correct.
crash
FBI's
data
experts.
retrieval report from the 2021 Lexus 570,
Correct.
report of autopsy,
Correct.
autopsy photographs,
Yes.
three-dimensional laser scan data of a Lexus LX 570,
Yes.
a VINLink, VIN capital LINK report sheet for the 2021 Lexus LX 570,
Yes.
expert autostats data sheets for a 2021 Lexus LX 570,
Yes.
and publicly available literature, including but not limited to the documents cited within the report, learned treatises, textbooks, and scientific standards, correct?
Correct.
All of those items and data were reviewed by you and your team in coming to your conclusions and opinions in this case, correct?
Yes, sir.
And I'd like to ask you one other series of questions concerning sort of who did what. Your report indicates that there were, in no small part, 2 undertakings, if I can ask them in terms of pillars: the damage to the vehicle and the injuries to the body of John O'Keefe, correct?
I would say that's a fair characterization, yes.
And I may be butchering this a bit because I'm not being very scientific, but were you more responsible for the vehicle damage or the injury damage?
The vehicle damage.
And who on your team was more responsible for the injury damage?
That would be Dr. Andrew Rentschler.
Obviously, Dr. Wolf, in coming to your opinions and conclusions concerning the damage to the vehicle, you had to consider the damage to the human being, correct, John O'Keefe?
Correct.
And as the team leader, in terms of Dr. Rentschler coming to his conclusions and opinions concerning the damage to the human being, he also had to consider the damage to the vehicle and the interplay of the two, correct?
Correct. We work together.
I was just going to say, is that how you two and Mr. Klein work together to come to the opinions and conclusions that are cited in your multi-page report?
Yes, sir.
Thank you. That's all I have, Your Honor.
Okay. Mr. Lally?
Thank you, Your Honor.
Good morning, sir.
Good morning.
Now, you went through a list of about 14 things that are contained within your report that your firm or your agency was provided with that you reviewed, correct?
That is correct.
Specifically review all 14 of those things, or was that done as sort of a team?
Yes, I looked through all of the documents.
So you personally looked at all 14 of those items that are listed within the report?
Yes, sir.
And you indicate that it was your opinions or what you did in this case that was, you were asked to answer specific questions, correct?
Yes.
It wasn't like you were just tasked with, hey, here's some facts, go do, or take a look at a crash reconstruction or rate a crash reconstruction. You were asked very specific questions and you tried to answer them the best you could, correct?
I don't know that there were specific questions. I think ultimately it was an open-ended question.
But related to two, you testified as to 2 specific areas that your firm or your agency looked at, right?
Those are the disciplines that the report covers, yes.
Well, you testified about some other areas of expertise as far as human factors, visibility, luminescence, things like that. You didn't do any of those things here, correct?
Luminescence.
Wasn't part of my scope in this case.
And the scope in your case, you indicate that it was based on the evidence, correct?
That is correct.
Now, to be fair, that's based on the evidence that you were provided, correct?
Correct.
So What should he have been
So what
provided
did
that he
Mr. Klein
wasn't?
do?
So as a part of the engagement with the entity that ultimately retained us in this, due to the confidentiality of it, only those who had access to the material to the file were allowed to review it and discuss it. And essentially, Scott Klein served as kind of another reconstruction expert to essentially bounce ideas off of and help with the review.
So for lack of a better term, sort of provided, let's say, sort of technical review of your work and Dr. Rentschler's work, is that correct?
I would say assist us with the analysis, yes.
I like how he did that. He totally disagreed, but made it sound like he was agreeing.
No, so your firm or your agency issued a report in relation to what you did, correct?
That's correct.
And you've obviously had a time to review that report as far as what's contained in there factually, as well as conclusions and opinions, things of that nature.
Yes.
So is it your testimony that anything that has to do with anything factually, conclusions, opinions, or otherwise, in relation to the motor vehicle damage, those are your opinions, those are your conclusions, correct?
I would say that's fair, yes.
And again, based on the evidence that you will provide, correct?
Correct.
And so the facts or evidence or conclusions or opinions related to injuries to Mr. O'Keefe, that was Dr. or Mr. Rentschler's area, is that fair to say?
Dr.
Dr. Rentschler, yes.
And again, that was based on the evidence or whatever he was providing, correct?
Correct.
Which would be the same materials that you had testified that you had, correct?
Correct.
I have nothing.
Anything further, Mr. Jackson? All right, so, Doctor, I just have one question for you. What specifically were you asked to do?
I'm sorry, Your Honor, I didn't hear the court.
What specifically were you asked to do?
So the agency that retained us gave us a selected quantity of file material related to this case, and essentially left it as an open-ended question. Ultimately, was the evidence consistent with a pedestrian interaction between Mr. John O'Keefe and the Lexus?
Okay, you said selected quantity of information. Who selected that information?
As far as I'm concerned, it would be the Department of Justice and the FBI.
All right, and they just gave you what they wanted to give you as far as you know?
We had no say in what material was handed over to us.
Okay. All right. Thank you very much. Any questions based on my questions?
No, Your Honor.
Mr. Lally?
Just briefly,
You sure?
and I
Lally?
apologize for this, I'm just unaware. Is it Mr. Wolf or Dr. Wolf?
Dr. Wolf is fine.
Dr. Wolf is
So, Dr.
fine.
Wolf, when you say that you were asked specifically whether or not the evidence, the limited scope that you were provided was consistent with a pedestrian collision, were you asked sort of in general terms as far as any type of pedestrian collision, or were you asked specifically as far as biomechanically could say the injury to the back of Mr. O'Keefe's head have been caused by contact with the vehicle? How open-ended was this question?
He said it was open-ended.
Again, I think it relates to, is the vehicle damage consistent with the pedestrian impact, and are the injuries consistent with the pedestrian impact?
And again, the whole panoply of injuries, is that correct?
I'm sorry, what was your question?
Let me rephrase. So did anybody specifically ask you to determine whether or not the injuries to the back of Mr. O'Keefe's head could have been caused by a motor vehicle?
I don't know that they asked us specifically. Again, they basically asked us to perform an accident reconstruction and biomechanical analysis and basically tell them our findings, and these are our findings.
And in the materials that you reviewed, did you see anything in there of any sort of statement, suggestion, intimation, anything at all that suggested that the injuries or the fracture to the back of Mr. O'Keefe's head was caused by a motor vehicle?
In terms of direct contact?
Yes.
No, I don't believe so.
Nothing further.
Anything?
Nothing.
All right, Dr.
Did you
Wolf, you are
consider
all
that
set, sir.
as part
Thank
of
you.
your, I mean, I would think you did. I mean, what a strange question. Doctor is fine. Dr. Wolf is fine. Oh, God, I love this guy. This guy knows how to testify.
I'm just going to ask you to be mindful of the court and step up. You're going to remain standing.
You solemnly swear the evidence you give the court in the case now here, the truth, the whole truth, and nothing but the truth, so help you God.
I do.
I do. This guy's got the East Coast thing going on.
Gotcha.
Gotcha. Is he from Long Island?
All right, whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Certainly. Dr. Andrew John Rentschler, Rentschler.
Sir, what do you do for a living?
I am a biomechanical engineer and accident reconstructionist.
In what area of the country do you live in?
I live in Pittsburgh, Pennsylvania.
What is your
Pittsburgh.
title currently?
How do yins
at your
like it up
company?
here in Boston?
I am a vice president and director of the biomechanics for the Midwest Division.
And what is the name of that company?
It's called ARCA LLC.
And what is the main mission of ARCA? What does ARCA do?
So ARCA is a engineering consulting company, and we have several different types of engineers, biomechanical engineers such as myself, accident reconstructionists, mechanical engineers. We look at crash worthiness, safety of vehicles, and other types of events. So we really do all types of work. We do litigation type work, as well as research and development for government and private entities as well.
Let me have just a moment, Your Honor.
Yes.
Can you give me a brief synopsis of the professional discipline of injury causation biomechanics? What is that?
So injury causation biomechanics is really applying traditional engineering principles to the human body. So as a biomechanical engineer, I look at the response of the body to accelerations and forces and determine how an injury occurs. You know, an injury to the human body is just an engineering problem. For instance, a mechanical engineer might look at a piece of steel and you know the size of the steel and the shape of it. And if you apply a force in a certain direction, that steel will bend and eventually break. Well, we do the same thing, but we look at the human body. How much force do you have to apply, and how does that force have to be applied in what direction or manner to get a specific injury, whether it's a skull fracture, an intervertebral disc injury, a concussion. So we look at the response of the human body to different forces and accelerations in different types of settings. And ultimately, our hope is to help mitigate or prevent injuries, whether it's in a motor vehicle accident, sports setting, industrial setting, auto pedestrian impact, try and make products and environments safer for individuals.
And that's different from what medical doctors, correct?
It is, yes, sir.
Little boy walks into an ER with a broken arm. The medical doctor wants to reset the arm and fix the arm, correct?
That's right, yes.
What does a biomechanical engineer want to learn about the broken arm?
We want to learn how that break or that fracture occurs. I always say that we kind of approach injuries from two different directions. You have an injury occur. After it occurs, moving forward, that's when the medical doctors get involved. They diagnose the injury, determine the best way to treat it, what's the prognosis. As a biomechanical engineer, I kind of take the reverse direction. We look at, here's the injury, here's what's diagnosed. Well, how did that injury occur? You know, how much force do you have to apply to cause that fracture? How did the bone have to be loaded? How did it bend to actually cause a specific type of fracture? So we really kind of approach the injury from two different directions.
Understood. And given that scientific approach, oftentimes you can come to conclusions and opinions, scientific conclusions and opinions about the causation of an injury, correct?
Absolutely. Yeah. And I mean, ultimately, that's what biomechanical engineering is how does an injury occur? Why did it occur? And what type of setting did the injury actually occur? What type of loading and what type of kinematics do you need to have this injury actually occur?
Can you tell the court a brief synopsis on the discipline of human factors? What part does that play in what you do for a living?
Well, human factors is a large part of it as well. I mean, from a biomechanical standpoint, we look at the body, we have to know anatomy, we have to know the makeup of the body, and then human factors plays a part of it as well as how individuals respond or what their response is to different types of environments or reactions. It really all plays into looking at a specific event. How did someone react? How did their body move? How was the body loaded? There's all different types of factors that you have to apply. The human factors, kinematics, kinetics, biomechanical, musculoskeletal interactions. It's all these different factors that are really involved in performing an analysis to ultimately look at injury causation.
Doctor, as the Director of Biomechanics and Human Factors at ARCA, what education, training, and background qualifies you to perform those duties?
Well, I got my Bachelor's of Science in Mechanical Engineering with a minor in Biomedical Engineering from Carnegie Mellon University in 1995. I then went on to get my Master's in Bioengineering and Biomechanics from the University of Pittsburgh in 2002. And then I got my PhD or my doctorate in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Can you give us a brief work history up to and before ARCA?
Sure. So I got my PhD in 2004, and then since then I've worked in the consulting field for biomechanics. I've worked for a company out in Davis, California for a while called Biomechanical Engineering Accident Reconstruction. I then joined another engineering company in Jacksonville, Florida for about 3 years called Chesapeake Engineering and Design. And I have now been with ARCA for approximately 16 and a half years.
And in those positions and in your position currently as a director at ARCA, do you specialize in research and analysis attendant to evaluating and studying the relationships between crash injuries, crash forces, human kinematics, and human tolerances?
I do. I mean, that's really what I do on a daily basis, whether it be in litigation type cases or the research and development we do for different companies or entities, or even internal research that we perform at ARCA.
Doctor, what professional associations and accreditations do you have?
I'm a member of the American Society for Mechanical Engineers, as well as the Society for Automotive Engineering. Now, with respect to biomechanical engineering, there's no actual professional licensure for biomechanical engineering. So a PhD or a doctorate is the highest degree you can have in that field.
Are you also a reviewer for archives, physical medicine and rehabilitation and biomechanical engineering online?
I am, yes. Well, usually if you publish articles in a journal, usually that journal comes back to you and asks you to be a reviewer. So I certainly do that type of work as well.
I'd like to ask you a couple of questions about your ongoing education, your professional education after your PhD. Have you continued your education in areas of biomechanics and high impact injuries from the NTSB?
I have. I've taken classes through the NTSB and SAE, the IPTM, Police Technology Management Training Center. There's several different entities I've taken biomechanical and accident reconstruction courses through.
So the alphabet soup, if you will, of biomechanical engineering and human factors.
Right, yes.
The alphabet
And you
soup.
continue that today?
I do, yes, sir.
Any specific training in human kinematics?
Yes, I do have training in human kinematics.
Just out of curiosity, how do you define what is kinematics?
So kinematics is the motion of the human body and looking at how the body moves. And it's irrelevant or irrespective of the forces that cause that motion. So we're really looking at for instance, how one body part moves with respect to the next. We can see how the body moves as a result of a specific type of event.
You mentioned injury mechanics previously in one of your answers. What is injury mechanics and how does that relate to biomechanics?
So again, that's a subset of biomechanics, looking at the response and the strength of the different parts of tissue of the human body. On a very basic level, to get an injury or have an injury occur, you need really two factors. You need enough force to cause injury to the tissue, and you need that force applied in the right manner. So if I wanted to fracture my elbow, I certainly couldn't take a hit on my shoulder and expect my elbow to fracture. Its force is exerted in the wrong location. And likewise, if I just lean my elbow on the counter here, that's not enough force. So you need the force and you need the application of that force in the correct manner to produce what we call an injury mechanism.
And have you ever participated in any studies or research in this area? In addition to your dissertation, getting your PhD, what about additional studies and research in this general area?
I have, yes, sir.
Can you describe that for us briefly?
Certainly. Well, just at ARCA, I've worked with the United States military. We worked on the design of the MRAC vehicles, the mine-resistant ambush protected vehicles over in Iraq and Afghanistan.
That's a troop carrier, correct?
That's correct, yes. And the issue there is they go over the IED, the improvised explosive device, and it blows the vehicle up off the ground. So you're getting very large forces and accelerations through the vehicle, through the seat, into the soldier's spines. So we're seeing very traumatic and severe spinal and head injuries. So at ARCA, we work on what we call an energy absorbing seat design. So when the vehicle gets blown off the ground, that seat is designed to absorb the force and the energy to protect the soldier's spine and their head.
Did you take part in the design of that seat?
I did, yes, sir.
Has that been employed by the Department of Defense?
Yes, it has been.
And are troops utilizing that new seat design, that safe seat design in that troop carrier to this day?
As far as I know, it's from what they'll tell us, yes, sir.
Understood. Are you also published in this field, Dr.?
I am, yes.
Can you give us a couple of examples of current studies that you're involved in or publications that you've done in the recent past concerning bioengineering and the impact or the association that it has with human factors?
Sure. I mean, and another project I'm working on is we work with the NHL actually at ARCA. We have an ongoing, we have an ongoing relationship with the Department of Player Safety. For instance, we helped redesign part of the rink. In every arena, they had at the end of the player area, there was basically a 90-degree stanchion where the glass met. And so players were kind of getting checked down in the boards and then hitting up against the glass. And actually, somewhat ironically, it was Chara hitting Pacioretty into the glass, the Boston-Montreal game, and caused a cervical fracture and concussion. And the NHL came to us to see if we could have a redesign of the rink to make it a little safer. So we took crash test dummies, the anthropomorphic test device, which you've probably seen on TV, the automotive manufacturers use them all the time, and threw them into different configurations of glass. And now in every arena in the NHL, it is basically a curved piece of spring-loaded Lexan or plexiglass, where the players now, they hit into it, it absorbs the impact, and they glance off of the glass.
Is that a design that you helped come up with?
It is, yes.
So both from the United States military as well as professional sporting leagues, they've come to you to help save lives, lower risk.
That's right, mitigate and prevent injuries, yes, sir.
What about crash and sled testing?
Yeah, I've performed a number of crash and sled tests. When you look at, any vehicle that's driven in the United States, it has to pass federal motor vehicle safety standards. There's federal regulations that they have to pass. And, part of that involves running the vehicle into a wall at 35 miles an hour, hitting it from behind, rollover type impacts. And they have these crash test dummies in those vehicles. So we perform a lot of testing for different cases and situations where we put that dummy in the vehicle and we evaluate the safety system, whether it's the lap and shoulder belt, or if it's the airbag or the seatbelt pretensioner, determine how to make the car safer. And part of that is looking at the force that's exerted on that dummy, because there's tolerance values. We know how much force it takes to cause specific injuries. So we want to make sure in certain instances, at certain speeds or impacts, that if someone's in an accident, the force acting on, say, their head or their neck or their chest is going to be below these established tolerance values.
Speaking of how much force it takes to cause an injury to a human body, have you engaged in any testing or published in the field of auto pedestrian incidents?
Yes, I've been involved in a number of studies where we're looking at auto pedestrian type impacts. Again, a lot of times we'll utilize the crash test dummy where we'll set it up and we'll actually have it struck by different vehicles or different objects to look at the response of the body. It's very important if you're talking about an auto-ped type impact. You have to know the configuration of the pedestrian, the vehicle, where they hit on the vehicle, whether it's a projection type impact, a wrap, a fender vault. It really all depends on how the person's positioned and the amount of force and speed involved in that type of an impact.
And staying with that for a second, that basic subject matter, have you also engaged in studies related to slips and falls where somebody might fall from a standing position and injure themselves either to their head, shoulders, whatever, and those kinds of of injury impacts?
I have, yes. And then one of the issues we look at it there is a lot of people fall, especially elderly people. So we want to look at what types of forces are being produced. You look at hip fractures, if you slip and fall backwards, head fractures. So we're trying to determine how to prevent those falls from happening and also create devices or products that can help actually prevent injuries if someone does take a fall.
Doctor, have you been retained as an expert in the area of biomechanical engineering and human factors in the past?
I have, yes, sir.
May I approach, Your Honor?
Yes.
How easy to understand is this guy?
Can you take a look at that document and tell me if you recognize it?
This is a list of my deposition and trial testimony.
Your Honor, I provided that to the court this morning.
Yes, I appreciate it. I had a chance to look at it.
Okay. That's about I don't want to go through everything. That's about a 14-page document. Is that correct?
That's correct, yes, sir.
Let me just ask it this way. How many times do you think you've been qualified as an expert in the field or testified as an expert in the field of biomechanics, biomechanical engineering, and human factors?
I've testified probably over 150 times in numerous state, federal, civil, and criminal courts throughout the country.
Your Honor, move to, I'm sorry, may I approach?
Yes.
For purposes of voir dire, Your Honor, I would ask that this document be marked.
Sure.
That would be par for the course, wouldn't it? Might be overqualified.
Have you ever testified in criminal court as an expert in biomechanical engineering?
I have, yes.
How recently have you testified in criminal court?
Well, actually, I've testified twice. The end of May, I think May 31st, I testified in McKean County, Pennsylvania. For the prosecution, it was a case where the defendant was accused of beating his girlfriend to death and basically said that she fell down the steps. So my testimony involved determining how her injuries occurred and that they were entirely inconsistent with what would have happened during a stair fall.
What about another case?
And then about a week after that, around June 6th or 7th, I testified in Cambria County, Pennsylvania, again for the prosecution for another homicide case where the defendant was accused of essentially beating his wife to death and then said that she actually fell backwards and struck her head, caused a skull fracture on the side of the sink. So my testimony, again, pertained to looking at the injury mechanisms and determining that his story of her falling back and striking her head on the sink, it's inconsistent with the injuries and the type of force that would have been exerted in that case.
In both of those murder cases, you were hired or retained by the prosecution in the case, not by the defense, correct?
That's correct, yes, sir.
Your opinions in furtherance of the prosecution's case in chief, not the defense case in chief, correct?
That's correct, yes.
With regard to this case, you were asked to look at several items. We've already gone over those in the other testimony, so I won't belabor that. You were asked to look at several items, correct?
I was, yes.
And ultimately, based on that series of information, that universe of information that you were provided, see if you could come to an opinion and conclusion concerning the incident before the court now, correct?
That's right. See if I could determine what happened, how the injuries occurred, and the events leading up to and during that process.
Without going into your conclusions and opinions, were you able to come to conclusions and opinions to a reasonable degree of science and certainty?
I was, yes, sir.
You were not hired by the defense, by me, or anybody on the defense side in this case, correct?
That's correct. I was not.
You were not consulted with or hired by the Commonwealth either?
That's correct. I was not.
It was a completely independent agency, is that right?
That is correct. Yes, sir.
Before this morning, have you and I ever met?
No, sir.
And you and I have never talked about the substance of your opinion and conclusion, correct?
We have not. That's correct.
You did reduce those opinions and conclusions in conjunction with your team to a report, is that right?
I did, yes, sir.
And your understanding is that report was made available both to the defense and the Commonwealth in this case, is that right?
Yes, sir. That's correct.
I have nothing further to ask.
Okay, Mr. Lally?
Thank you, Your Honor.
Good guess.
Just a few questions for you, sir. Good afternoon.
Good afternoon, sir.
Now, with relation to your work in this instance, in this case, were there any limitations as far as confidentiality or anything that were put on you or any of your team?
What do you mean by confidentiality?
As far as who, what, where, and how you could discuss what you did?
Well, yeah, I mean, certainly we just discussed with who we were retained by in this case. I don't believe I discussed the case with anybody else except for my cohorts who were also involved in the case.
And so my question, sir, more is geared towards, at some point you were made aware that your report and your findings were made available to both the prosecution and the defense in this case, correct?
I was made aware of that, yes, sir.
And when you were made aware of that, was there any limitations on given to you as far as who you could discuss your report, your findings, or anything with?
Yeah, basically given the direction or the request that I don't actually discuss the substance of my opinions or my report with anybody aside from who we were originally retained to work for.
Now, may I approach, Your Honor?
Yes.
Sir, I am going to show you the first couple pages of your report, specifically right down the bottom. There's a list of items 1 through 14. I ask you to just review those.
Okay.
Now, is that the totality of information that you and your firm were provided with in reference to what you did in this case?
I believe it was, yes, sir.
So nothing beyond that list of 14 things did you have occasion to look at, review, or have any opportunity to see at any time?
Well, aside from we did do testing in this case, so we did do other
Aside
work.
from your independent testing, I'm asking as far as material provided by whoever employed you, that is a sum and total of what you received, correct?
I believe that would be correct, yes, sir.
And did you personally review each of those 14 items? Because, and I don't fault you or your company for this, but within the report, there's a lot of we. So what I'm asking is, did you personally review each of those 14 items that are listed in that report?
I did personally review every bit and every page of information that was provided in this case, yes, sir.
And
Good try,
to be
Lally.
clear, just to sort of close the loop on this, when it comes to those 14 items, were you allowed to ask for any additional items, or was it just you were limited to this is what you have, go form an opinion?
There may have been discussion about if there's other information available, but I believe ultimately that we rendered our opinions obviously just on this specific information that was provided to us.
Now, as far as your opinion in your report, when was that issued?
February 12th of 2024.
So that date on the top of the report of February 12th, 2024, that's when you sent the report to the people that contracted you to do the analysis in the first place.
That's correct, yes, sir.
May I approach you?
Yes.
Thank you.
Sure.
Now, am I correct? And what I'm trying to ascertain here, Doctor, is just sort of the different roles that you and the other members of your team performed in reference to this. Am I correct in that your primary role in this pertained to the sort of biomechanical engineering analysis of injuries
I'd love to hear
sustained
this
by
guy
Mr.
say not
O'Keefe?
sort of.
That would be correct, yes, sir.
And not to put too fine a point on it, but Dr. Wolf would have been more responsible for issues related to the vehicle itself.
Generally speaking, yes, that would be correct.
Obviously, there's some interaction between damage to the vehicle and injuries to Mr. O'Keefe, but as far as your primary sort of any opinions contained within this report pertaining to injuries to Mr. O'Keefe, those would be your opinions, correct?
Yes, any opinions or information with respect to the injuries would be my purview and my opinions in this matter, yes, sir.
And concomitantly, so any opinions related to damage to the motor vehicle, those would be opinions of Dr. Wolf, is that right?
Well, to some extent, I mean, certainly I would have opinions as well based on the interaction or alleged interaction between the body and, for instance, the vehicle in this case, and what damage to both the body as well as the vehicle you would expect. So I think there's basically some overlap between those issues. I wouldn't say that it's a complete separation.
And so, and again, Doctor, what your opinions or ultimate conclusions are, whether they be yours or Dr. Wolf's or a combination of the two, it's all limited based on the information and the evidence that you received, correct?
It certainly is based on the information that we reviewed and listed in our report. Yes, sir.
Which
Now-
is something you can cross on, Lally.
As far as for the mandate or from the agency that hired you, were you asked to answer a specific question, or were you asked to just do an analysis based on what we sent you, or how was that put to you as far as what you were doing?
There was a specific request that we were asked to perform and to evaluate in this case.
And specifically what I'm asking, sir, is there's an analysis in there of whether or not the injuries to the back of Mr. O'Keefe's head could have been caused from contact with the vehicle, correct?
That is part of my analysis and opinions, yes, sir.
And were you specifically asked to address or answer that question by the agency that hired you?
That was one of the questions I was specifically asked, yes, sir.
I have nothing further.
Anything further, Mr. Jackson?
Your Honor, thank you.
All right, so Doctor, I have a couple of questions for you, sir. So regarding this specific request, what were you tasked to do specifically?
So specifically overall, I was tasked from the biomechanical standpoint to determine or see if it's possible to determine how the injuries in this case occurred. And part of that was determine whether the injuries, the head injury and the arm injuries resulted from contact with the Lexus in this case.
Okay. And regarding all of your prior testimony, a good deal of it seems to be in depositions. Any of those in Massachusetts?
There's a couple, I believe. I've testified at trial in Massachusetts,
Okay.
Middlesex Superior Court.
Do you know where that might be? I do want to look at that.
I can find it for you, maybe a couple of months ago.
Was it in a criminal case or a civil case?
Oh, it was in civil case. I
Okay.
think, let's see here. Yeah. So let's see. There was one November 14th, 15th, 2023, Middlesex Superior Court. That was probably the most recent
Okay,
one.
what number is that on there if I want to go
that
back
one-
and look at it?
That is number 310.
Thank you. Is there
Number
another Massachusetts
310.
case?
Oh, I'm sure there are, because I know there's some from earlier in my career. Let me see.
Because I'm going to want to look at that.
Real quickly here.
Really?
Read this.
Didn't want to look at anything where Trooper Paul's testified. That didn't matter.
Connecticut. Ellsworth, Louisiana. Oh, there's 68. I'm gonna butcher it. Worcester.
Worcester. Is that a civil or criminal case, Doctor?
That is a civil case as well.
Okay. What year was that?
Oh, that one was 2012.
Okay. Any others that you think of or you see?
There may have been a couple others. I don't recall off the top.
All right, I'll go through it more closely. I
Sure.
appreciate you saving me some time.
Absolutely.
All right, any questions based on my questions?
No, thank you, Your Honor.
No.
All right, you are all set, sir. Thank you very much.
Thank you, Your Honor.
You are all set, sir. I get a little tired of that script, too. You're all set.
All right, so Mr. Lally, I will hear you on your motion. Now, we didn't get into the ultimate opinions and the basis for that opinion, but I'll hear you on your motion.
Your Honor, essentially what Commonwealth was seeking and had been seeking was just in reference to that, as far as who did what and who was responsible for what and what were the items reviewed, and is that the totality of it? There's a date on the report. I don't know if that was a date as far as when it was filed, when it was opinion was rendered, when that was provided, what was provided to them in the course of their analysis. So I think
You're satisfied?
very simply what the Commonwealth had been seeking for the most part was covered today.
Okay. All right, I have some questions as to the scope of the testimony of the witnesses. So, Mr. Jackson, you intend to have them testify consistently with the report, everything covered in the report?
Correct.
And the conclusions, all 4 conclusions in the report?
Correct.
All right, Mr. Lally, what's your take on this?
Inviting him to challenge any or some of it? Can we hear the gears grinding as he tries to think
I do have
up
an
a
issue with number
reason?
4. I don't think they're qualified to testify to. I don't think either of them is qualified to testify to that. That's more of an area of forensic pathology.
What do you say to that, Mr. Jackson?
Number 4 is, their opinion is, there is currently insufficient evidence to determine the cause of Mr. O'Keefe's skull brain injuries or the circumstances surrounding the event. That is well within the scope of their expertise. Obviously, I don't think I have to beat this dead horse. They are highly, highly qualified to review all 4 opinions. And if the evidence in their opinion, their expert opinion, to a reasonable degree of scientific certainty, which is what's evidenced here by the report, is that there is insufficient evidence to determine the cause of Mr. O'Keefe's injuries, then that is an opinion that they are well within it's well within the scope of what they can testify to. That's their opinion, that's their conclusion. Mr. Lally is going to have an expert, Trooper Paul, who's going to differ, or who has differed in that opinion.
Karen's
And I would have
expression
kept
there.
it out. Remember, I would have kept out any medical part had there been an objection. And when you objected, I sustained the objection.
I think we're talking about 2 different things, apples and oranges. That's not, Trooper Paul's opinion is that his injury or his injuries, or I think he said variously that it was blunt force, could have come from the curb. Or
He
it was
did
blunt
say the
force
injuries
because
were
the road was
consistent.
blunt. That was his opinion, and he was sticking to it. This is contrary to that. Both of these individuals have come to the conclusion and opinion that the evidence is insufficient to support that determination, and it's well within their purview to testify to that.
Your Honor, if I may, I don't think that's their actual opinion. I initially didn't think of it in these terms as it's phrased on the cover page of the report. If you look at the actual opinion
I
and
was looking at
findings,
the last page. Are they the same on the front and the back?
I think the front is a little more definitive and concerning. The back, I think, more as to it's consistent with a whole multitude of different things. So the fact that I don't really think that's an opinion at all, to be honest with you.
All right, I'll take a look at this more closely, give you a decision Thursday. All right, I did not expect it to go this quickly. We could have had the jury here, but I'm sure you all could use the afternoon to prepare. All right, Mr. Lally, let me know Thursday if you need, are you ready to go forward at least with your case on Thursday?
Oh, yeah, sure.
Let me know Thursday if you need additional time. If I let these witnesses, if I let Dr. Russell testify, how that impacts our schedule.
Absolutely, Your Honor.
All right, but I don't want that to be a concern of yours, how it impacts the schedule. That's my concern. I just need to know. All right, so anything else?
For the Commonwealth.
I think that's it. Thank you.
Okay, we'll see you Thursday morning.
Great. Well, that reminds me a lot of Judge Bev's bluster on the third-party stuff, right? I'd be well within my rights to exclude this all, but I'm going to give you leeway to try to make her sound like I'm a generous God, right? Here I am being so generous with you. No, you're really just following kind of the basic requirements of the law to not get yourself reversed. It's out there. Jackson's not arguing it. It's just one of my minor complaints with him that I have because, you know, I've spent most of the last part of my career as an appellate lawyer. I want the record clear. I want the basis for your objections to be clear. I want you to address the law. I want you to address the law and not just, get all caught up about the finger pointing that happens in discovery disputes all the time. Nobody cares about that. This judge doesn't care about it. The Court of Appeals doesn't care about it. You guys are the only ones who care about that. So it is my one beef, because the legal standards here are so incredibly favorable to the defense. So incredibly favorable to the defense that I really would like to see him focus a lot more on that. I haven't even seen that they filed a memo in response to what the Commonwealth filed. I don't know if they did or not. Ultimately, it doesn't matter, frankly, because even the Commonwealth's memo, we're gonna talk about some of the law in there. I've talked about it before. We'll go ahead and revisit that. Is extremely favorable to the defense. So, really didn't like how Bev talked to Dr. Russell there. Really didn't like that at all. So condescending there from the bench. Do you mean a reasonable degree of medical certainty? She said what she said. She said what she said. She's not going to use your little meaningless legal speak. It means nothing from a scientific perspective. One of the issues I forget if it's the National Academy of the Sciences report or the PCAST report, it's one or the other, that we were talking about at the very beginning of this stream here. The critiques of forensic science in general, is about this language, reasonable degree of scientific certainty, because it means nothing at all. It means nothing at all. And all it is just a bolstering method for the expert to be able to make it sound like that's somehow scientific, validated, objective. No, it's his own opinion of his own opinion. Of course he's going to be like, I'm pretty sure about my own opinion. So it's just this nonsense phrasing that has come under challenge. There have literally been court cases about this language. There have been some federal courts that have said, no, you don't get to use that. It doesn't mean anything. And all it's doing is just trying to make it look like there's more here than there is. Scientific certainty is phrased in things like error rates and degrees, standard deviations, things like that. It can be calculated and expressed that way. And if you can't do that, if you can't express it in one of those terms, then you're talking about a subjective determination, which is fine. You can be really sure about something subjectively, but you don't fluff it up and make it more than it is by trying to cast it in this reasonable degree of scientific certainty. It's not scientific certainty. It's just your opinion. So I didn't like that whatsoever. She doesn't use your little double speak, and somehow that's a problem. That's a reason to be talking down to her like that, and then telling Mr. Jackson she had a problem with her testimony, being able to say that. She doesn't have to say that. She doesn't have to say that. It's not required. It's not anywhere. It's not a foundation to be able to offer a scientific opinion, to use these magic words. What kind of idiocy is that? This is why, this is the problem with science in the courts and the illiteracy on the bench. Okay, it's a running joke that the reason people become lawyers is because they weren't good at math and science. Those people became doctors. The people who were good at the social sciences, the humanities, they went and became lawyers. People on the debate team became lawyers. People that did, the Math Olympics stuff, those guys became the doctors and the engineers. And I just feel like that stereotype is really, really being lived out here in this courtroom. Yikes. Dr. Wolf, who did the damage to the vehicle analysis primarily. I really liked him. He's a very skilled witness. Just in this little glimpse that we got, oh, this guy is sharp. He knows how to talk. I absolutely loved. He disagreed with Lally to his face, but said yes, he made it sound like he was agreeing with him. But then he just reworded it as exactly what he thought that answer was. Fantastic. Fantastic. I'm not sure what Lally was going at here. I looked at all the documents. Yes, they looked at all the documents. Did you think you were going to catch them? Well, no, I only looked at part. My opinion is incomplete. I limited my scope of what I was going to look at. I really don't know what he thought he was going to get there. And then Dr. Rentschler, both of them are great in terms of just being able to articulate things very clearly, sophisticated, complicated concepts very clearly because they understand it. There's that saying about if you want to know if you really understand something, teach it. If you're able to communicate it and break it down into simple terms, yeah, you understand it really well. And so what a contrast with what we heard from Trooper Paul and that just word salad that was being spun from the stand, where we're just going, what? I hear words here and I hear big words, but they don't relate to any sort of meaningful idea that's being communicated. This guy can break out something like, what's kinematics? Very simply, oh, it's about how the human body moves. We can all understand that. Yeah, it's about how the human body moves. 14 pages of where he's testified and when. And you need to know specifically Massachusetts. No, you don't. No, you don't. There's no rule that says you have to have been qualified in that state before, because it wouldn't even make sense. How would anybody ever become an expert? Everybody has to testify for the first time at some point. So what if they've never testified in Massachusetts before? They don't get to be an expert in Massachusetts? Absolutely not the rule. Not even close. Really interesting stuff I thought about the ice hockey rink and the seat design for the MRAPs. That's cool. That's cool. That's cool stuff. That's cool stuff. Yeah, that's insight into just the practical application of these types of principles that he's going to be talking about to literally help people from suffering serious injury. You just redesign the environment so that the forces upon them act differently. So then how do we like Bev volunteering, inviting from Mr. Lally? Mr. Lally's saying, this is fine. That's all that's in the scope of his motion. They need to clarify, who relied on what and so forth, and clear all that out. And I'm not sure if they're qualified to do it. They're extremely qualified. They are accident reconstructionists. They have obviously so much better qualifications than the Commonwealth guy does. But then we're going to go beyond the scope of that at the judge's instance. She's going to invite him. Why don't you take an issue with conclusion 4 here? Really? Why don't you just go sit at the prosecutor's table, Judge? Why don't you just go sit at the prosecutor's table and run the prosecution yourself? Instead of this farce of sitting on the bench and doing that while you're wearing a robe. Judge Bev has no shame either. She really does not. It's just becoming so overt. The assist she is offering the Commonwealth here. Why don't you focus? Why don't you address that? It's not even in your motion. It's not even in the motion. So we'll get the decision Thursday. Here's my prediction. She's going to go through and do some ticky-tack limitations on probably all of them. I think she will let Dr. Russell testify, and we'll talk about why. I'll get to your comments. I'll get to this case law. We'll talk about why. Yeah, I think she's going to let Dr. Russell testify. But she'll be ticky-tack. She won't let her say anything about, the taillight injury. We'll ignore the fact that she has at least as much experience with motor vehicle pedestrian impacts as she does with animal bites in the ER by her own testimony. But they'll cut that off, for whatever reason. And then maybe she's going to limit this fourth conclusion that we got sort of hinted at. Jackson read it. It's the conclusion was that there's insufficient evidence to say that John O'Keefe, it wasn't clear to me if it was just his head injuries or all of his injuries were caused by a motor vehicle collision. Well, that would kind of take the ability to challenge the Commonwealth's case off the table, wouldn't it? What is the possible basis for having a problem with that conclusion? What's the possible problem? It's their job to look at the forces that have happened, that have occurred, the damage they produced, the evidence that was discovered as a result, and think through, given the limitations of the laws of physics. Cars, have gravity. Humans have gravity, are going to operate on both of them. So it's not like the car is going to suddenly take off and fly and hit him in an odd direction. No, there's a limited universe of possibilities of how this accident could have occurred. And a limited number of configurations between the body that was affected and the car that struck it. So you can rule out a front end collision, right? Because that's not consistent with the taillight being broken. So, yeah, isn't that part of their job? Look at the possible ways that a motor vehicle collision could have resulted in this damage to the car and that damage to that body, this configuration of stuff on the ground. Don't know what the possible problem there could be. He thinks it's only a forensic pathologist can testify to that. Based on what? Based on what? Because you think so? Because that limitation would be advantageous to your case? No. A witness can be qualified by education, training, or experience. And these guys clearly have education and training and experience in looking at how forces act on the human body in the context of a motor vehicle collision. So they probably have quite a bit more technical experience there than the forensic pathologist is going to have. She might have looked at more motor vehicle accidents. She might have done more autopsies. But that doesn't mean that she has the kind of knowledge about the forces involved and all of that type of stuff that these guys have. So, different arenas. Yeah, kinda. Kind of slightly different contexts. But same general area of expertise. There's absolutely no reason why this would need to be limited to a forensic pathologist. Especially given that, like they're pointing out, there are interaction between these two things, right? If the forensic pathologist is going to conclude, well, I can find that the injuries to the arm are consistent with the taillight scratches. Well, now that whole failure analysis that he was describing, right? Materials, at what point will a material fail as a result of a force acting upon it? Well, that becomes pretty relevant to that determination of whether it's consistent or not. Okay, maybe it's consistent with his injury, but it ain't consistent with the composition and structure of this taillight. So that's what I mean by You know, in many ways, these guys are, you know, potentially kind of better qualified to answer this sort of thing than the person who just did the autopsy. So that's my prediction. There'll be some little ticky-tack exclusions, but nothing overwhelming. You know, nothing complete. Like, she's not going to completely say this doctor can't testify because it's not the defense's fault. They are not acting in any kind of bad faith here. The evidence was clear. She came to them. She initiated the contact. She discovered who they were. And yeah, then he reached out to her by phone after he already knew that she was kind of volunteering herself to help him out with the case. So he doesn't have any control over that or over that timing or anything like that. Let's take a look at some of your comments, guys. We got quite a bit to get through here. Entry required. Commonwealth late with witness list. Also, defense needed time to respond. It's clearly been a back and forth type of situation, you know. So if this had been a situation where Commonwealth disclosed late and then defense had to scramble to respond, you know, that's then we're just looking at, is this in a reasonable length of time? You know, did they act reasonably under the circumstances and get it to the Commonwealth as quickly as they could? But it turns out it's not even that situation. It's that the witness found out about this and volunteered herself, and they have absolutely no control over the timeline of something like that happening. Boom her. The judge got after Lally because 2 weeks before trial, the DNA tests were still not complete because Lally was not returning calls from the lab. Well, did she though? Because that evidence came in. The defense had moved to exclude that for these same reasons, late disclosure. And that evidence came in. We heard it. That was the whole mitochondrial DNA analysis. And so the defense had dropped their objection to that. They had argued to exclude it, and I don't remember which day it was that came up, but they did say on the record they were withdrawing their opposition to that. And it's basically because that testimony was not damaging. Number one, it tells you absolutely nothing about the provenance of how the hair got there in the first place. And second, we did the math sitting here in the court based on, sitting here in the stream based on the exclusion and in the exclusion rate that the witness testified to tells you necessarily what the inclusion rate is. You can just run the math on the inclusion rate and it's like 300 and some thousand people. So this is not particularly damaging to John. So it's just a situation where Karen does not have an unlimited war chest as much as she might like to. Everyone would like to. Money is no object, but you have to decide what your priorities are. So are you going to spend more time fighting this particular issue that isn't really that damaging in the first place? Or are you just going to go ahead and focus on other things that are higher priority? Sleepy Boy with just the super chat. Thank you so much. Sleepy Boy, I wish the general public had an understanding of how easy it is to get a grand jury indictment in state courts. The old saying, a prosecutor could indict a ham sandwich. It's a completely one-sided process. There is no real limitation on it. There's basic general due process principles of they can't present false evidence. They can't deliberately mislead the grand jury. But beyond that, not really a whole lot of protection. And the bottom line is, in this case, what the grand jury heard Michael Proctor's case. And we've heard all through this what he chose to do and what he chose not to do. There's no requirement that you do a thorough investigation before you go to the grand jury and then present them with all the exonerating stuff. Yeah, no, they don't have to do that. They can do exactly what they did, go in and cherry pick with their tunnel vision. Just look at the things that would support their theory of guilt and their target, their suspect that they've targeted. Present that to the grand jury, and you've got an indictment. And it's a low standard. It's the same probable cause type of determination, which As much as Tully wants to try to blow that up into something it's not, yeah, no, it's not a more likelihood than not. It is not a preponderance of the evidence standard. It's just, does it look pretty good? Pretty good that it could be this person? Yeah, then you got probable cause. Extremely easy to get a grand jury indictment. Yellow Pill NP, the process is the punishment, subscribes. Well, thank you. I have lived through this process with many people for many, many years, and it's been a little bit shocking just in the context of this case, seeing how overtly these law enforcement officers and these prosecutors specifically employ that with this whole bringing the witness intimidation charges against people. What the hell is all that? What is all that? The voir dire from Lank. He gets in a chippy conversation with the guys at the gas station, and so now you're going to leverage your position to bring the power of the criminal justice system down on those men to punish them for what? Not being charged before? That's their fault. You're going to get them for something. You're going to get your pound of flesh. A lot of this process is about getting the pound of flesh. Doesn't matter if she's ultimately acquitted, as long as she had to suffer in the process of getting there. Melissa McSweeney, curious if more will be said about the basement. Well, we'll probably have to wait for the defense case for that. I am definitely intrigued, since it is now very clear that the new owner let them in the house. I mean, they got to do that video after the door had been replaced, the basement door to the bulkhead. Had that nice, like, hydraulic door. That thing was super cool. Not the old janky thing that the Alberts had on there that, according to them, you'd never have it open because it didn't work. Stuff like that. No, the new owners let them in to walk around, do that video, show what it would be like to go from the basement door through the fence over into the front yard, right there conveniently near where John O'Keefe was found. You do just kind of gotta wonder what they might know. Michelle Hamister, I'm a mechanical engineer. Can I use my knowledge as a juror to explain physics in a deliberation? So this is a great question because, it's a little bit of a gray area. The prosecution is going to say no, of course, absolutely not. That would be evidence outside of the record. It would be misconduct to do that because it's not something that has been testified to in the court. But the instructions the jury is going to get is going to tell them you are allowed to bring your common sense and your life experiences into the deliberation rooms. You're not expected to put all of that aside. You're not expected to just be a vacuum walking into your jury duty. I mean, that's just not realistic. So yeah, everybody has backgrounds and experiences and things like that you get to rely on when you go into deliberation. So for example, very normal in deliberations to talk about an alcohol-related case. Well, what's your experience with that? We've all seen drunk people. Does she look like a drunk person? Why do we or do we not, do not think she looks like she's acting like a drunk person? It's the kind of common sense stuff, the kind of experience-based stuff that people get to rely on. So are you supposed to then, as a mechanical engineer, go in and pretend you don't know anything about mechanical engineering? Well, I'd argue that's not very realistic, is it? It's not very realistic. So, very good question. Very good question. I don't have a crystal clear answer for you on that one. Michael Corey found a few cases in Canada where Whiffen testified. His opinions seem to have been accepted in those cases. Anyone interested can go to canley.org. Yeah, I mean, the bar to be an expert is not particularly high. Why it's suddenly being really high for these highly qualified guys is not real clear to me. Not real obvious from a scale balance standpoint why these guys are having such a hard time meeting that when they are so obviously qualified. But generally speaking, yeah, no, it doesn't take a whole lot. It really doesn't take a whole lot. And just Trooper Paul there, Trooper Rimmer is kind of the walking example of how that goes. Solo YOLO, these TMU troopers are just, yeah, that is kind of what they are, huh? Dollar store accident reconstructionists. Plain iron, we do as thou will, says the prosecutor. We do as thou will. The prosecutor is supposed to represent the community, and that's kind of the fiction behind the grand jury in the first place, right? The whole reason that there's a grand jury process is that it's supposed to be the community check on the prosecutor's exercise of that power, that very significant power to take somebody's freedom away, haul them into court, require them to answer a very serious accusation and face serious consequences if they lose. The grand jury is supposed to be the check on that. The reality, of course, is that it's a fiction because the prosecutor has control over what the grand jury sees and has the opportunity to really shape the process. To send it in the direction that they want to go. Because how many grand jurors are going to go in and be so knowledgeable about the process that they're going to understand you can reject everything this prosecutor says. You can take the reins. You can take the reins and run the investigation and run the show. They have that power. But how many of them know that? And do you think they're told? Do you think they're told that? We don't have grand juries in Washington and at the state level. It's not that we don't have them. It's just that it's not required. We get to charge criminal defendants here on the basis of a probable cause affidavit filed by a law enforcement officer and a judicial determination that that's good enough. That's all we have. No preliminary hearing, no grand jury. I have definitely argued that is not consistent with the Fifth Amendment grand jury process. Don't see how that makes sense, but that's the way we do it. The courts have long ago disagreed with me. Cool 29. I like how she says, I disagree, then tell the people she agrees with to make their case. I hate accusing bias, but this seems fishy to let the state do things and not the defense. Yeah, the judge is being unfair. It's just such a common complaint that it does become a little bit trite. Like, of course, everybody who is on the wrong side of the judge's decisions think the judge is being unfair. But the problem here isn't the being on the wrong side of the judge's decisions. It's that we can see the process the judge is using for ourselves. And it is not the same process for the defense and for the prosecution. She is not treating them the same. It's right in front of our faces. She's over here, trying to catch Mr. Jackson on like these little technicalities. She's expecting him to mind read, while at the same time you're volunteering arguments to the prosecution to support their position. I mean, it's just kind of nuts to me. It's so in your face. In this particular case, I don't like accusing of bias either, because it's kind of like everybody in every case always thinks the judge is biased, but we're seeing it happen is the problem. We can look at today's hearing and without even knowing what the ruling is, we can be like, wow, that was really not fair to the defense, how she handled that. That was really not fair. Franz Marx, agreed, Andrea, fine remedy, but why do these rules apply unilaterally? Well, some animals seem to be more equal than other animals in Judge Bev's court. And that's really all I can say about that. The mitochondrial DNA and not excluding that for the same basis, right? The late disclosure. Why do we need to think about that? She was thinking about that for weeks and weeks and weeks, not making a ruling on it. And she's going to decide this in 2 days. I mean, it's just kind of nonsense. The Chungi Show Live, they need to do something about the sound in that courtroom. It is not that big, but nobody can hear anything unless people are yelling, apparently. Yeah, there's all these different levels of sound problems, right? There's the sound problem there in the courtroom, which I don't, it seems weird to me, like why they would be having such a hard time hearing, but I believe it's because their sound equipment, it's not amplifying in the courtroom. It is just there to pick up the sound for the feed for us here at home, or, you know, whoever's watching on Zoom or whatever. It's the Zoom court system. So, if they're not near the microphones and stuff, we have bad sound at home. If they're not projecting their voices, they have bad sound in the courtroom. It's just a terrible combination of everything. If it's hard to hear, get some amplification in there. It's not rocket science. It's sound engineering, you know. Engineering does seem very difficult for a lot of these folks who work for the government side of things. DPAT, questionable rulings should go to the defense. It seems opposite with this judge, always giving the benefit of the doubt to the state. Well, yes, I definitely agree with you. When in doubt, you should rule in favor of the defense. That's just being cautious. That's just being cautious given what's at stake. It's cautious given the configuration on appeal and the likelihood of, you know, what can get reversed versus what can't get reversed. The defense is not going to be complaining about pro-defense rulings. So if you're concerned about it standing up, give them the benefit of the doubt. But that is definitely not what happens with this state. She's over here giving Mr. Jackson a hard time about the timing and exactly how he said that the intermediary contact happened. Like, she got the wrong idea, but maybe she asked a bad question. While at the same time, Mr. Lally over here is misrepresenting what was said in the pretrial hearings about Mr. Yannetti and what he had to say about the dog bite evidence, which wasn't the dog bite evidence at all. It was, is there an issue about the dog DNA? No. So they're not challenging that. That's all that was about. Defense is not moving to exclude the dog DNA. They're fine with it. They'll just, you know, deal with it with their own case. Turn that into something else and not a peep. Not a peep. Not a problem at all. No, well, Mr. Lally, do you think that was really a fair representation of what happened in that court proceeding? Nothing like that. No, to the contrary, she gets mad at Mr. Yannetti for defending himself. Yeah. Bobby Walter, I wonder if she knows what forensic evidence is. Yeah. What do you mean scientific evidence? I can't believe he said that. I really can't believe he said that. Like, did you want to be memed into oblivion? Keep saying things like that. That's how it happens when you're supposed to be a scientific expert. Ridiculous. Horror Vibe 666. What, if anything, qualifies you as a badass doctor? What doesn't? I mean, my goodness. What an impressive resume. Well, I was an ER doc, okay, which is like such a badass medical role anyway, you know, my personal opinion, if you're looking at like the doctors and you have them on the badass scale. I mean, yes, the ER doc, hello, in the trauma center in freaking Los Angeles. Yeah, this lady's a badass. But she still had intellectual curiosity about the forensic stuff. She still had that interest. So what'd she do? She pursued it. And then she did all these other things on the side. Very impressive lady. Steve F. Lally Slacker gonna question Dr. Russell. Left my F ass off. Yeah. Going to question all of them. I mean, he has really seized the stage in terms of the actual courtroom presentation of this case. He's got the assistant DAs helping him with his briefing and probably, you know, some of this administrative stuff, the coordinating with the witnesses and things like that. But no, when it comes to formulating the convoluted meandering questions, that's going to be all on Mr. Lally. Denise H with the super chat. Thank you so much. Yellow Pill NP. I want to be her when I grow up, right? Is there still time? Do I still have time to be her? You know, I have thought back in my time in the criminal justice world, and I've thought, if you could do everything over, would you take the same path? And generally speaking, I think I would. But I have thought to myself, you know, the alternative that I could see doing the forensic pathology. I could see me doing that. I could see me doing that. I could see that being just being very fascinating. The crypto tax lawyer. This is how you tender an expert. We will hear Lally on the hot mic kill me instead of Guarino. Boom. I mean, when you're like looking at your watch to wonder when are we going to get through the witnesses' qualifications. Yeah. That's a good expert. She's written articles on dog bites, on dog bite injuries and what makes them unique. Yeah, she's pretty much the go-to on this subject, I would think. Track worker Bev. I'm sorry, ma'am. Yous are overqualified. That was a little Long Island. Yous are overqualified. More like that. I'm sorry. Yous overqualified. I don't know. I'm mixing up my Mass and my Long Island, and there's probably a little Mid-Atlantic in there too. Yeah, what's her problem? What's her problem with these people? They are so clearly impressively credentialed and experienced. I don't know what her problem is. Theory neutral. The BPD will love Dr. Russell. They and their women seem to love strong intellectual women, or in their lexicon, CUNTS. Yeah, but is she hot? Does she have an ass? That's all that will matter. That will be Mr. Lally's cross, right? Could you get up and demonstrate? Could you do a full turn for the jury? We need to inspect the posterior. Steve F. Chloe, I bit him. Good one. No, I said, did I? It was preceded by did I, and it ended with a question mark. SanDB, wow, a real expert first time. Yeah, so far in this case. Now, I don't want to discount too much the cellular forensic people, because they are very qualified in their area as well. I thought Jessica Hyde had a very impressive resume. The guy yesterday, not so much. But she had a very impressive resume. You know, I think under most circumstances, yeah, that's the type of person that the defense would be looking to hire to do a review like this too. So it's just that when you look at kind of the weight of what's come out here, you know, the weight of the expertise, we haven't had a single PhD on the state side, on the Commonwealth side. We're going to get a medical examiner, an MD. His complaint about Dr. Fowler, I was going to mention that too, how that was late disclosed. We'd never heard of this guy. We just let it roll. I think that was a fair point, but on the other hand too, it's kind of not so much, because he wasn't being offered as an expert. He was really there as a fact witness to the processes and procedures of that particular emergency room, that particular hospital, because he's there to, you know, try to validate that it could not have been an alcohol swab that they used when they took her blood sample that they then later ran to do the retrograde extrapolation. I mean, that was the bulk, really, of what he was there for. So that is an expert stuff. There's no opinion about that. It's just there to testify as a fact witness. But, you know, I think the defense is making a strategic mistake here if they think that if we keep our hands clean, we just roll with it, we act like the good guys, that they're going to get some reward for that. No, they're clearly, at this point, I mean, it was clear weeks ago. It was probably clear before they got to trial. That's not how it was going to go. there's going to be cheap shotting here, and you're going to need to be prepared to give some of it back. We're not seeing the same kinds of objections from the defense that we're seeing from the Commonwealth, the same kind of attacks that we're seeing from the Commonwealth. And I do question some of that strategically. Maybe you shouldn't be so Mr. Nice Guy. Maybe you should go ahead and ask that the rules be applied even-handedly to both. If I can't ask a bad question, maybe Mr. Lally shouldn't be able to ask a bad question. Hold him to it. Hold him to it. Farrell Drake, if Bev excludes it, what percentage do KR's chances go down to LYO? If she excludes, I'm convinced Bev is in on the cover. Yeah, I'm not going to put Bev in any sort of like knowledge position of what's going on here, other than just how much the rest of us can see with our own eyes from having watched this trial. Like, we get it. There's a reason why public opinion goes the way it does with a trial, right? And it's not a conspiracy. It's because we have become informed over the past nearly 8 weeks about what's going on here and why they've charged her with this in the first place, what their basis is. Yeah, we know more. And that's the process of developing an opinion. You get the information and you form it. The jury is doing the same thing. The jury is doing the same thing. The only restriction on the jury, and it's a good restriction for all of us too, and I think most of us are applying that, is that you need to keep an open mind. You need to always be willing to consider additional information, additional evidence. We've been waiting. We've been frankly begging the Commonwealth here. Show us, show us, show us. Show, don't tell. Remember that basic principle of what makes a good case and a good trial attorney, good strategy? Show, don't tell. If you have overwhelming evidence of guilt, like Trooper Proctor says, you don't have to say it. You can just show it. You can just show it. We've been waiting for it. I'm still waiting for it. Still open to it. Just losing faith the more time that goes by that I'm going to get anything like that. So, yeah, we all see there's a reason why public opinion goes the way it does. It's not because we're all in on some conspiracy. We're all biased against the Commonwealth. No, it's because we see what happens. We see what happens over the course of the trial and form an opinion based on that. So Bev is no different. She sees not only what we see, she's seen more than what we've seen. So, you know, she knows at least what we do as far as, you know, reasons to be suspicious of this investigation and at least some of these investigators. But it's more just more of the same that we see with this cover-up kind of theory in the first place. It doesn't require all of these people to be knowing participants. It just requires them to pick a side and decide which side they're on, and then conduct themselves in a way that is informed by that inclination. So, seems pretty clear Bev has picked her side, because she's revealing it in every single one of these hearings with the standards that she is holding the defense to, that she completely excludes the Commonwealth from. The assistance she provides to the Commonwealth, the boost that she doesn't give the defense. So that's where you know my issue is with Judge Bev. Not that she's like knowingly in on anything, but it's just become clear she's picked a side. Don't think she's impartially applying the rules here. Teresa Kaufman, Andrea, Jeff, I thought Bev said she wasn't going to exclude the witness today. She was going to give the second bite at the apple, and thanks for your insight. So that was talking specifically about the scope of what the questioning was going to be of Dr. Marie Russell today. She wasn't saying, I'm going to let her in, I'm not going to let her in. She was basically saying, if I let her in, then, you know, we're going to need to know what the scope is. And because of the late disclosure, it kind of all needs to be on the table. So the Commonwealth is getting the second bite at the apple in the sense that if she goes in now and testifies at trial, they already know here's what her opinion is, here's what it's based on, here's how she's going to express it. Which is not, I mean, not really problematic to me, because, you know, she gets a second bite at the apple too. She gets a second bite at the apple too. Now she knows how this guy is going to come at her, and the kinds of things that he's got. And she's practiced her testimony. So my view that the dress rehearsal helps the witness much, much more than it helps the prosecutor. Zulu 11, Q prosecution expert post-mortem raccoon bites. It was the owl. Is that what Bob over at Defense Diaries, his theory, it was the owl. I have continued, you know, to wonder if these are post-mortem. I do. Nobody's said anything, and hypothermia is involved, so maybe it's just all complicated, but there's no bruising, there's no swelling. It doesn't look like a bite like that I've ever gotten. And if he was warm enough to develop swelling and bruising in the eyes and on the face and stuff like that, why wouldn't he have them on the arm? I don't know. I'm not the expert, so very likely there's a reason for it. Yeah, can you find somebody within a week, Mr. Lally? That's pretty much a tell. That's how we're going to handle it. She's going to let it in, but she's going to probably limit it. And then Mr. Lally is going to be able to bring in, I wonder if, oh gosh, what was his name now? Spacing. Depthy Heard. That ridiculous doctor. Ugh. Spiegel. Wonder if Dr. Spiegel's available. You know, you got to do some basic anatomy in med school, and you got to go to med school to be a psychiatrist, so that's probably qualified enough, isn't it? Maybe Dr. Spiegel's available. Entry required. Did you see John O'Keefe's brother's face? He looked pretty grim today. He looked pretty grim and angry, but not really clear who that was focused at. Not really clear who it's focused at. He seems to have an awful lot of resentment towards the defense. For what? Being right? For having a case? For having qualified experts that they can present? I don't understand that. I really don't. The crypto tax lawyer. Marie is a twofer. No auto deaf Chloe. Boom. I'd be careful, Lally, especially in front of the jury. Should never have indicted. Yeah, she is a twofer. A 2-for-1. Great expert. Such a broad range of expertise, right? Both in the pathological stuff, which is some more crap from Lally. What, she can't testify because she hasn't done an autopsy since the 90s? No, I don't buy that. Would she be qualified to go in and do an autopsy today? I guess not if she's not board certified, but I don't know. I don't know what the requirements are. Could she go in and assist with an autopsy? Probably. Arla 7247. Question. Residents of home injured J.O. frantic. They dragged him by his feet to get him out of sight till they figured out what to do. Dog grabbing at his arm while being pulled, possibly. There's so many different ways I could see this happening. You know, I could see that he got beat up in the house, you know, fell, cracked his head on the concrete or something like that, gets the concussion, you know. They realize immediately something is messed up. Maybe he's like having seizures or something. I mean, that kind of thing, it sounds grotesque, but it happens. Very common. He ends up in the pose. God, what's that called? Fencer's pose. Like they can tell what type of brain injury you have by the pose that your body takes when you freeze up and get the injury. Crazy, this neurological stuff. So I can definitely see a situation where something like that happens. They panic. They throw him outside in the backyard. Maybe let him bleed back there. You know, don't bleed in the basement. Bleed back there, and he gets worked over, you know, by the dog while he's in the backyard. I can see a lot of ways this could happen. It does seem defensive though, doesn't it? Because that's how you would block the dog. If the dog is trying to attack you, you would use your arm. Vicky McNamara with a super sticker. Thank you so much, Vicky. Very kind of you. Sylvia's daughter, please, we explained the woman with the microphone, one thing near her mouth. That is the court reporter. She is not doing the conventional stenography where they have a type system, which is like, it's like a phonetic alphabet that they use to take their shorthand. What she has is a system where she speaks, she restates everything that is said in the courtroom, but she has a verbal shorthand that she does instead of a typed shorthand. So that's what that system is. I've never seen it in person. It does look very strange to me. People have different names for it, like the elephant's trunk. I've seen it referred to, this piece of equipment. But it's basically a talk to type of equipment. And one of the reasons they like it, they have instant transcription now software for everything. Like even if you do the finger typing stenography, they have software now that will turn that into like a fairly instant kind of transcript. And there's still pieces they would have to go back and fill in. But, to edit it and finalize it and stuff. But it gives you an instant transcript. That is one of the advantages, though, historically of this type of system, is it was able to produce, a draft transcript on really short notice. So that's who she is. She is the court reporter. Entry required. Dr. Russell reached out to MADA first. She reached out to the LA district attorney. And yes, she did reach out first. That is what she said. She saw it in the Boston Globe. Lally trying to make this whole thing out of, well, it's disturbing. She described, maybe she wasn't interested in the case because maybe this is the first time there's a headline that like suggests there's a dog bite. Maybe this is the time it caught her attention. Like she's somehow supposed to know and care about this case in Massachusetts on your time frame. Just ridiculous. Everage, could you explain why central to the case matters and why it overrules late disclosure? If already explained, take my super chat as a thank you. Nope, I saw this come up and I've been waiting for it. And this is why I went ahead and pulled up some case law that we're going to go ahead and share with you right now. So let me get it up here. These are the cases that are cited in the Commonwealth's brief. Okay, I've got just 3 of them here because they're all consistent. I'm gonna scroll through to the part that basically matters in this particular case. They go into discovery violation. So this is a situation where there was a jailhouse informant and then the defendant went and got information, like other writings from this jailhouse informant that had come up in another case. It was impeachment evidence. It's not something they would have introduced independently, but it just became an issue because the witness was going to testify. So it was just going to be offered in response to that. So they didn't produce it to the Commonwealth. And their argument was we don't have to produce impeachment evidence. But it, would have impeached the credibility of the witness by documenting his attempt to trade favorable testimony to both sides of a civil case in exchange for an exculpatory statement or lenient treatment on the case's criminal counterpart. So he's putting himself out to bid. My testimony can be tailored to the benefit that I get for it. That's a pretty big indictment of somebody's credibility in a case where they're being an informant, presumably getting some kind of benefit from the Commonwealth. So, prosecutor, it was produced the first time during cross-examination. Prosecutor complained, we're prejudiced. It should have been turned over and under Rule 14. And defense argued they had no obligation to turn over impeachment evidence. The court says, no, that's not the case. You had an obligation to turn over impeachment evidence, if not under the rule, then at least under this order, this pretrial order for discovery that was out there. So, you don't get to hold that back. And it's not a special exception. So then here's where we get to the interesting part. Once it was determined that the defendant violated the discovery order, it was incumbent upon the judge to fashion an appropriate remedy. We have not reviewed the exclusion of statements sought to be used for impeachment as a remedy for a discovery violation. However, the factors taken into account in reviewing the exclusion of an undisclosed witness are applicable to this situation as well. Those factors are 1, prevention of surprise, 2, evidence of bad faith in the violation of the conference report, 3, prejudice to the other party caused by the testimony, 4, the effectiveness of less severe sanctions, and 5, the materiality of the statements to the outcome of the case. So to get specifically back to the super chat, that is why central to the case matters. It's material. Materiality is one of the factors that has to be considered here. And that, again, is because of the constitutional right to present a defense. You have something that is central to the ultimate issue of the case. Are you guilty or not? There needs to be a good reason to disclose that is beyond just, well, maybe there's a slight technical noncompliance with the rules here. In the weighting of priorities, getting the right outcome when it comes to a criminal conviction needs to have a lot greater weight than just technical types of obligations. So these are why, evidence of bad faith and materiality, those are some of the most important considerations here because they're literally the factors in the test. So if the defense team didn't act in bad faith here, it's not like they set on Dr. Russell and sandbagged the prosecution with her. They had no contact with these FBI people, apparently at all. The ARCO guys that got hired by the FBI, no bad faith on the defense there. So that's a factor that goes very strongly in their favor. And then the materiality of the statements, a dog caused these injuries. Yeah, that's pretty important. That's pretty material because it's consistent with the defense theory of the case and the third party culpability. So yeah, pretty material. If the jury believes these are dog bite injuries, then they don't buy the Commonwealth's theory of the case. Very central to the outcome here. So what's interesting in this particular case, the judge found the Commonwealth's plea of surprise to be genuine. Okay, Commonwealth here saying, we didn't know someone was going to testify. This is a dog bite. You've known about this dog bite theory from early on, at least over a year, right? You're not surprised by there being a dog bite theory. In fact, you were so prepared for it that you went and did a whole set of DNA testing to try to prove it wasn't a dog bite. So you knew this was coming. You had every opportunity to ask your own medical examiner, some other forensic pathologist. You had the opportunity to go and consult with Dr. Russell yourself and get an opinion on, hey, the defense says this is a dog bite. Is it a dog bite? So the plea of surprise here is really self-serving and just not particularly credible. The only thing that is a surprise here is the fact that the defense got somebody highly qualified to be able to say that. The judge also found that defense counsel acted in bad faith in failing to turn over the statements to the Commonwealth because he found the omission was deliberate. It was calculated to gain a tactical advantage. Bad faith, he did it on purpose. It's gamesmanship. So actually found that in this particular case. But the question that remains is whether less severe sanctions are appropriate, even when the counsel is acting in a strategic way. The preclusive sanction should be reserved, I gotta say this like Boston, for hardcore transgressions. Hardcore. We expect that the extreme sanction of conclusion would be imposed only when the Commonwealth is prejudiced significantly by surprise and there is no reasonable alternative means of achieving the purpose of the rule. Court should only apply this sanction when convinced that a failure to comply with an order was deliberate and prejudicial to the Commonwealth. So I don't think we're going to get to deliberate here. There's no showing of deliberate. And now the question is simply the prejudice to the Commonwealth is the only way that it can be cured by excluding this witness. Well, no, because she's already, number one, you're not surprised now. It's been fully disclosed to you. We had this voir dire here in court. You know what the testimony is going to be. You know what it's going to be based on. So you can go and respond to that. And she's giving them the opportunity to do that. You can bring in a rebuttal witness to respond. How long is it going to take? She says, that's my concern. Don't worry about it. Don't worry about it. It's my concern. Yeah, it is, because you can recess the trial. You can put a pause on things if it's, not something that can happen in a week. You can put a pause on it, hit the brakes, get through the 4th of July weekend, come back after that and deal with it. Yeah, the jury's not going to like it, but if we hadn't been dragging our feet with the Commonwealth and the snow and the band at the waterfall and the shoveling the apron, for all of these unnecessary hours, well, we wouldn't be in that situation, would we? In some instances, granting a continuance may be such a reasonable alternative. Where the stakes are high, as they are in murder cases, preclusion is the last resort. Before prohibiting the use of undisclosed material during the cross-examination of a witness or prohibiting a witness from testifying, the judge must make explicit his findings regarding the 5 factors outlined in Durning, especially his consideration of alternative sanctions. So that's the main case here. This is the Commonwealth's brief. The Commonwealth's brief. There's 2 others that I pulled up, but I'm not gonna bother to share them at this point because they're the same thing. They're the same thing. They're all cases where the trial court said no, I'm not going to let that in, and it got reversed by the higher court saying you didn't apply this standard correctly. So that's why it matters. That's why it matters. Even the Commonwealth's own law that they cite recognizes that's what the standard is. Preclusion is the last case resort only if you can't fix the problem any other way. And you got to make specific findings that the problem can't be solved any other way. It's so favorable to the defense that this is why I'm like sitting in my chair, kind of like Mr. Jackson, use that. The whole saying when the laws, when the facts are on your side, pound the facts. When the law's on your side, pound the law. When neither's on your side, pound the table, right? The law is on their side here. The law is on their side. I would have loved to have seen that law being pounded. This is a murder case. Highest possible consequence. Preclusion must be the last resort. So much good language in there. Just would have loved to have had it. Would have loved to have had it laid out in court. So that's why it matters. This is central to the defense theory, and the defense is not at fault for the lateness here. It's not because they engaged in some type of gamesmanship. It's because she came forward late in the day. To me, that's pretty much about the end of it. So yeah, I tend to think if she were to exclude this witness entirely, yeah, that's appealable. Frankly, even excluding part of it, potentially appealable also, but it just depends on why. Is it because it's a sanction or because she's saying the witness isn't qualified to testify to that? Well, they can, readdress the foundation if she is allowed to testify. How are you qualified to give an opinion on whether a taillight would have caused these type of injuries? Lay the foundation. Maybe. I don't know. The crypto tax lawyer, Dr. Marie equals divine intervention, in my opinion. It's just so reminiscent of the Depp v. Heard once again, isn't it? All those witnesses that came out of the woodwork once she testified. Morgan Tremaine. She is the Morgan Tremaine of this case. The TMZ employee who's like, yeah, that's nonsense because she's the one that leaked that video to TMZ, the cabinet slamming video. If you haven't seen my video on that, on Morgan Tremaine and the whole like TMZ saga in that case, I got a whole series on it. Check my archive. It's a fun one. Queen Bee Canada became a YouTube member. Welcome. Thank you for joining the crew. Hope you like your time here. Rudoka, surely there's a trooper who took a 40-hour course in dog bites. I doubt it. I doubt it. I doubt it. They don't want to know about dog bites. They're the ones that have the dogs. They're the ones whose dogs are biting people. So the less they know, the better. If you know a little bit too much about dog bites, you can be held responsible for those dog bites. The crypto tax lawyer, Andrea, I have not thought Bev was completely biased pro-prosecution, but today takes the cake. She put words in Dr. Russell's mouth, re-certainty. I have been, I keep trying to fight the conclusion. I really do, because I want to give her more benefit of the doubt, and I just can't. She's putting it in my face how one-sided her perspective is here. It's just, I can't, I can't do the cognitive dissonance that's necessary to maintain the illusion that Judge Bev is being fair and even-handed and unbiased. She's just not. She's just not. And today, yes, illustrated this extremely well. She led, she cross-examined the expert to put words in her mouth. That wasn't what she said, and she doesn't have to say your magic words. Really have been trying, but she's just taken away that option. The crypto tax lawyer, the only uphill battle defendant faces is hashtag Bush League Bev's bias. It really is one of the biggest obstacles here. And I understand how the defense is feeling in the situation, because I know the frustration of when you're fighting not just the other side, but you're also having to fight that judge. You got the two front battle going on. You're Napoleon, but you didn't decide to invade Russia. You didn't make that decision. These things came to your doorstep. Maybe there's a better two front battle that was a purely defensive battle at some point. I don't know. Somebody's got a good historical one there. Go ahead and drop it in the comments for me. But yeah, I've been trying for so long to figure out what the problem is, and I just don't know. I do wonder, is it Mr. Jackson? Is it the outsider celebrity lawyer coming in from California that she needs to put him in his place? Is that what it is? I mean, she didn't like Yannetti either. When Yannetti was the outsider from Boston, maybe that was just enough. But boy, compared to Mr. Jackson, Yannetti's a hometown boy. Is that what this is coming down to? These aren't regulars in her court. These aren't her people. They don't do things her way. Not her regulars. She's going to put them in their place. I have to wonder. I can't make a lot of sense out of it, because it sure is not based on the quality of the Commonwealth's case or their presentation. This has been lousy. It's been embarrassing. This has been an embarrassment to the Commonwealth of Massachusetts. Kyle Murphy, does the defense have any recourse to the judge's misrepresentation of the doctor's certainty? What they need to do is they need to prep their witness, and they need to help her understand that nobody in the courtroom is on her side. They are, but nobody else in the courtroom is on her side. And so she needs to anticipate snakes in the grass, yes, even coming from the bench. Now, Judge Bev can't ask her questions in front of the jury like that. So, would have been good to have that conversation maybe beforehand. If this is not somebody who regularly and routinely testifies as a witness, they aren't necessarily attuned to the process like that, the way somebody who spends their life litigating is attuned to it. So they don't really have recourse, from a legal standpoint. Once she adopts the words that Judge Bev put out there and said, yeah, that's good. Well, that's her testimony now. She adopted it. The recourse is to train her not to let the words be put in her mouth in the first place. Watch that other guy. See how he did it. Where he said, let's see if I can find specifically what it was that he said. Because it was just so good. It was just so good. I don't think I wrote down the specific. Question or answer. Authored all the papers, the third-party agent, qualified, not paid by either side. It had to do with Mr. Klein's role. Lally seemed to maybe want to blow up Mr. Klein to argue, only masters of or bachelors of science in mechanical engineering means he's not qualified or something like that, which is still silly. It's better than an associate's in criminal justice. But so he had asked, was he there as mostly a reviewer? And the witness, Dr. Wolf, said, yes, I'd say he was there to assist us with our analysis. So he makes it sound like he's agreeing with Lally, but he's using his own words. He's actually not agreeing with Mr. Lally. Mr. Lally is saying, oh, this guy was just like a peer reviewer. And he's saying, no, he assisted, but he says yes. And so I love how he did that. Because it makes him look agreeable. It makes him look not unreasonable, but he also is not allowing the words to be put in his mouth. So that's how you do it. That's your remedy, your recourse, your way to avoid this becoming a problem in the first place. Is just be better at resisting having other people's words be put in your mouth, because those people are not your friends. Duncan, Idaho, that last guy doesn't have only an associate's degree and a 2-hour state-provided web training under his belt, so Lally is skeptical of his expertise. They're shameless. They're so shameless. Look at who they put on the stand and look at what they're complaining about. And yeah, they did elicit from this associates guy, his injuries are consistent with a motor vehicle accident. Yeah, they elicited that. Anybody on the planet think they personally are less qualified to give that opinion than that guy was? Absolute nonsense. The crypto tax lawyer. Now Bev knows better than DOJ, FBI. Let me also translate Lally. How screwed are we? The scope of what they were provided. I mean, what, you think the FBI just opens their entire file to every expert? No, of course they don't. It's limited to what they're asking this person to be involved with. Like, do they need to know all the stuff about the Sallyport videos? No, they don't. Do they need to know the witness statements? No, they don't. The witness statements have nothing to do with the physical evidence of the accident. Their scope is limited to physical accident. What people say has no effect on the biomechanics, on the materials, on the forces. None. It has none. So that's not their concern. The fact that, none of that would be produced to them is not a problem. Franz Marks, what a difference between these experts and the goobers that Lally has presented. 100%. 100%. Steve F. Solo Cup King is scrutinizing FBI's evidence. Yeah, we can't forget the Solo Cup. Can't forget that. Though we don't know how to use evidence tape, people are challenging the forensics. Yeah, pretty rich. Lily Smith, it is strange that she got rid of the dog so fast. I took less issue with the timeline of the dog once it became clear the timeline of the dog bite incident, because it was more than a year after this, you know, so that didn't particularly bother me. It did make sense that, yeah, okay, your dog goes and gets in a fight and bites a person. Yeah, that's a potential liability. That's something that you know, if you're going to get rid of the dog, that's when you're going to consider it. They never thought any of this was going to come back on them anyway, you know. They said, don't look at that arm injury over there. Don't think about a dog bite. They never thought that was ever going to come back around on them. So I don't necessarily have a problem with that particular timeline. That's just me personally. Arla7247, verdict is in. Dr. Wolf is a fox. He's a smart guy. He's a smart man. Young man. Didn't see if he's got a ring. I'm sure people will be scoping that out. Duncan, Idaho. I bet the state's rebuttal witnesses will have shiny bald heads too, and that will be listed as a qualification. Lally has a type. Yeah, once we get Trooper Paul Ryan back here on the stand on Thursday. He's the one that's really out of place in all of this. Be funny if he showed up with a bald head, wouldn't it? John Scott, he's acceptable, Your Honor. Doctor is fine. Dr. Wolf is fine. Oh God, I loved that. I loved that. Is it Mr.? Dr. Wolf is fine. That guy, watch out, man. He is deadly. He is deadly. Kyle Murphy, her contempt for perfectly nice people is awful. Yeah, that's what I didn't like about the treatment of Dr. Russell, is it was very patronizing. Do you mean reasonable degree of medical certainty? Those are the words you're looking for? No, she's using her own words. Not your little empty sciencey speak. Kurt Smith, not being a lawyer, how could this expert be kept from testifying? He seems, I can't count all the zeros there, a nonillion times more qualified than any of the Commonwealth witnesses. Yeah, he is. I mean, they both were. We get back to that same test. What's the basis for excluding this? So he's having to, you know, from a discovery violation standpoint, there's no discovery violation here. These guys both got it from the same place. They both got it within the same time frame. So how could they not be qualified to testify to this? If you got a problem with the insufficient evidence to conclude a motor vehicle accident, you think there's maybe something else that they should consider that would be definitive? Well, that's cross-examination. Go ahead and bring that up in their cross. And you know what? If you got a real strong point, maybe you'll get a gotcha. You'll have your little Matlock moment on the stand. Oh my gosh, I never considered that. You're right. The taillight did scratch up his arm, and that's how it happened. And in fact, he probably did a pirouette when he was flown. Yeah, it's ridiculous. It's just one of these things. Once again, when it comes to the admission of evidence, the trial judge has a lot of discretion. She has a lot of discretion to decide, has the floor been met? Does this person have the basic qualifications that they need? Is the opinion within the scope of what they're qualified to testify about and about what they in fact investigated and analyzed? Feel like we got a pretty good record here. Entry required. Boston Globe will be on fire tonight and tomorrow. They're like, yes, fist pump. They got that call out on the global stage, but then, you know, a little sad trombone. Well, I don't think I subscribe anymore. Just one I had for 6 months or a year or something like that. Don't think I subscribe anymore. Well, we won't clip that part. Duncan, Idaho. Mr. Lally is the worst kind of lawyer because he's disingenuous and underhanded, but in the most plodding, uncharismatic, and boring way possible. He's the lawyer version of a silent but deadly fart. Yeah, he kind of is. He's the lawyer equivalent of projectile vomit. No, that would be interesting. That would be interesting. Yeah, it's kind of in the hierarchy of evil and dangerous people that you don't want to run across. It's a little bit of a toss-up with me whether bad and smart is better or worse than bad and stupid. Bad and stupid can be really super dangerous, because they don't appreciate risk that everybody else does. They don't have the strategic thinking to think things out, down the road. So they can make really dumb decisions where if you as a smart person are trying to strategize around them, it's like playing with dumb people at the poker table. I hate the worst thing. This is why, like, if you go to Vegas and you play poker, you can't play at the low stakes tables. The 3-6 table is where all the dum-dums go. People that have never played and they're just there to blow. You got to go to the higher stakes table, the 8-16 table, the 10-20 table, because those are the people that know how to play. When people don't know how to play poker, they get dumb luck on their side. They make dumb calls. You can always play by the math in poker, like good poker players. You're always playing by the math. Every bet that you make is based on your pot odds and things like that. And so the whole idea is just you may not win any particular hand. Luck may come against you in any particular hand, but over time, if you're playing the math right, you're going to consistently be on the right side of those decisions. But, dumb people at the table can just really throw off how often it happens that the bad luck will tank your hand. Because when you're playing with other people that are good, they're also doing what you're doing. They're sitting there and they're calculating their odds and they're going to know, oh, my outs don't look good. They're going to know when it's time to get out of that hand and when the odds don't favor them staying in and continuing to bet. Dum-dums, no idea. So they can just blow up everything. And that's what this guy reminds me of. He reminds me of playing poker with somebody who doesn't know how to play. And you don't know what they're going to do. And that can be very frustrating and difficult to deal with. Cassandra S. Scientists use 95% probability standard Chi2 analysis. Yeah, the typical 2 standard deviations of the 95% confidence interval. That is pretty standard. And then there's also, for things that have known error rates, 2 out of 3 times you'll get a false positive or something like that. Those types of things can be accounted for. Those can be reported too. So that's what scientific certainty is. It's expressed mathematically, not a reasonable degree. A reasonable degree doesn't mean anything at all. Those are empty words. They are not the words of a scientist. They're words of lawyers who don't understand science. Desert Cat, I wish you could advise AJ on these points. AJ, hit me up. I'm here. I'll brief for you. Happy to help. Kyle Murphy, with all the never-ending sidebars about scheduling yesterday, Bev dropped the ball on pacing. Yeah, we could have had the jury here. Well, this was on you. You said, we're going to need a full day because she's so mad, right? Because it's the defense's fault that all this is happening. It's the defense's fault that the Commonwealth is bringing a motion. So she's very frustrated. This is going to take all day. And then, lo and behold, it doesn't. Entry require deviations, p-values, etc. Yeah, exactly. These are objective things. These are things that don't require somebody to sit and think, well, is this reasonable or not? Is my opinion reasonable? It's just the dumbest thing ever. Who is ever going to say, no, my certainty is unreasonable. I'm very certain, but it's not reasonable. stupid. Duncan, Idaho. Trooper Paul, is the crime scene in the room with us right now? What does it say? Can you show us on the doll where the crime scene touched you? Yeah, I mean, we already have apparitions in this trial, okay? We have a testimony that somebody apparated, I think it was Berkowitz, apparated out of the Sally Port on video. How low can we go? Why is the Commonwealth going this low and the defense brings in multiple PhDs and there's a problem? If that just doesn't illustrate the uneven playing field that we're dealing with here, I just don't know what does. Southern Gigi, do you think the dog testimony gets in, then the jury gets the whole story, right? Yeah, I do. I think she's gonna let it in because I think she has to. I think it is clearly reversible if she doesn't. It's clearly reversible if she doesn't. There is no bad faith by the defendant. This is material. The Commonwealth is not that surprised. Their little play here at, oh my gosh, we had no idea. No, you've known. You've known since, I think it was May of 2023, that the defense says this is a dog bite. Look at it. Look at it. It looks like a dog bite. You just didn't know who they were gonna put. You didn't know they were gonna get somebody who was gonna be able to medically confirm that, but you always knew they were gonna argue that. Their theory is that it was a dog bite. You weren't surprised at all. Nothing precluded them over the past year plus from going and finding their own expert to say, no, this isn't a dog bite. Rube, so sorry the jury missed today. Well, you know, like I said, this is the dress rehearsal, so could very well be that when the jury does get it, opening night, whole different energy. We'll just have to see. Teresa Kaufman, thanks so much for your insight. Do you think Bev will exclude the testimony of any of these witnesses today? Yeah, I do think she's going to limit. I do think she's probably going to limit both of them. She's sort of signposted that. She's probably going to limit the accident reconstruction guys on that insufficient evidence to conclude a motor vehicle collision. I don't know what her problem is with that. Maybe she'll explain it, but seems to think that's beyond the scope of what they can determine. I don't know why. I really don't know why. It's their job to look at what the evidence in the case is and form a conclusion about it. And if the Commonwealth thinks, well, there's other evidence they weren't provided that would give them sufficient grounds to conclude there was a motor vehicle collision, bring it up and cross. That's my perspective on it. But I don't think that's what she's going to do. I think she's going to go ahead and split the baby, give the Commonwealth their little, little whatever, their little advantage, and give that little smackdown to the defense. But no, I don't think she's going to exclude it entirely. She's going to let the doctor, Dr. Russell, testify consistent with a dog bite. Won't let her testify not consistent with motor vehicle collision, taillight scratches, etc. And then the other guys, really sounds like she's already signposted. Not going to let you do that opinion 4 about insufficient evidence. So that's my prediction. Haley Wolf, do you think the ARCA doctors watched Paul's testimony? The thought of that makes me giggle. I don't know what the Massachusetts practice is on this. And so a lot of the times, and in my experience, the expert witnesses, they get excluded they're accepted from the exclusion order, the witness exclusion order that says, you don't get to be in the courtroom, you don't get to talk to other witnesses and things like that. A lot of that is just for efficiency's sake, because they are supposed to be responding to each other. And so sometimes you need to be able to test that or like run some math off of that or something. And it doesn't make sense if they're on the stand and the first time you're hearing about the other guy's theory, and maybe you need to run a complicated calculation to verify it or have an opinion about it or respond to it or whatever, it doesn't make any sense for you to have to sit and do that on the stand. So it's pretty normal, just so that you aren't like calling people back and forth and making them waste all this time. They can go ahead and prep that ahead of time. And then just the other reason is because they aren't interested in the case in the same way that like percipient witnesses are. The people that are directly related to the action, that have the potential motives to tailor their testimony, to fabricate things, to make their story fit what the evidence is coming out. Like, I don't know, like maybe having to do with when you looked at YouTube videos about raining men and a basketball team and stuff, that it doesn't seem like the forensics backed up. Yeah, starting to look like that testimony was maybe a little tailored, But the experts, they don't have that type of interest. So they're just not, they're not assumed to have those same kinds of incentives at play as people who have more of a direct interest in the outcome would be inclined to do. So don't know what the standard is here in Massachusetts, if they get to listen to the other witnesses or not. I hope they did. I really do. I mean, in a way though, I kind of hope they're not, because I would love it if the defense could like read some of his transcript testimony to them on the stand to ask them their opinion about it, and then we'd get that cold reaction. He said, "What?" That could be fun. Be rational and nice when in this global sandbox. Canton, math, physics, logic, different universe than. It really seems to be, people can fly through the air and bounce, and taillights can explode in all directions, and people can apparate in and out of Sally ports, and a Jeep with a plow can both be and not be in the same place at the same time, and Karen can both go and not go to 34 Fairview the following morning. I mean, there's no consistency here. There's nothing coherent. Carazola X. Why should I let your expert in, Mr. Jackson? Your Honor, Trooper Paul. Jackson should only need 2 words to get any expert he could ever want in. Different animals. Those animals are not, some are more equal. Some are more equal than others. Rube, I heard number 4, insufficient evidence to determine what actually caused injuries, i.e. they weren't provided evidence of close proximity to inebriated BPD MMA fighter and ATF agent with potential grudge. You might have heard that. I didn't hear it real clearly what he was saying. He was too far away from the mic. So I didn't catch the exact words. I just heard the insufficient evidence and the injury. I thought he was saying to conclude motor vehicle injury, but I buy, if you listen closer than I did, that's what he said. I mean, yeah, there's a whole universe of things that could potentially cause the injuries. So you need some evidence of what actually happened to be able to make that determination. And if the FBI didn't provide that and just provided them with the evidence of this scene, these circumstances, this motor vehicle, this guy, then no, of course they don't have enough evidence to be able to rule out, the entire universe of other possibilities of how he could get these injuries. Dude McGuy, the idea that Bev has problems with these witnesses' expertise but had no qualms about Trooper Paul completely demolished any benefit of doubt I was holding for her. One of these things is not the same. There is just no way that you can hold these guys on an equal kind of standard. At the same time, did the defense challenge Trooper Paul's qualification to give this type of opinion? I don't know that they did. I don't remember that in the motions in limine. They're not fighting the same fight as the Commonwealth is fighting. They're fighting a good guy fight, and I understand, and I generally approve of that. You should be the good guy in court. It's best, but that doesn't mean that you don't fight hard and you don't use all of your weapons. I wonder if some of this is too much of the defense not rocking the boat. They have strategic reasons for deciding why they're doing it this way. Maybe they don't want it. It would take more time. It'll piss off the jury. Jury sees you objecting all the time. They can get annoyed with that. There's a lot of reasons not to do that. But it's just seeing how all of this is played out and the fact that it looks pretty unequal. We're looking at it in hindsight and we're armchair quarterbacking, you know, so it's hard to judge that decision, you know, from a distance. But I just wonder, have they played too nice? Have they let the Commonwealth slide on too much of this stuff? Alex Kane, Professor Russell, thank goodness for boomers and their auto-renewing newspaper subs. Came for legal analysis, stayed for the Stasi snark. Long may both continue. Well, thank you very much. I mean, if it's snarkable, we're going to snark it. You know, don't give me so many things to snark about if you don't want to hear it. Cranky. Doesn't the FBI investigation put an inordinate amount of pressure on the DOJ to convict? I wouldn't say that it puts pressure on the DOJ to convict. So first, in this particular context, since we don't know even really what the investigation is still. We just have guesses about it based on, you know, the little drips and drabs, the context, the letters that the DA Morrissey has written to them complaining about it. We just have kind of an idea of what it's about, but we don't know. So it's not even clear how big of a scope this particular investigation has in the broader scheme of what exactly is the DOJ doing here. Just as a general principle, it's less that the FBI investigation puts pressure on the DOJ to convict as much as that it just gives them a lot of resources to be able to do that. The DOJ has a very, very, very high conviction rate. Now, yes, a lot of factors in here, things like the plea bargaining pressure, the way that the feds operate can be a little bit of a high pressure system. For example, a lot more common, from my experience anyway, that at the federal level, they'll threaten somebody who doesn't plead guilty, goes to trial if they're going to testify on their own behalf, threaten them with perjury charges. A lot more common for the feds to do that than at the state level. And just things like having, you know, pretty hard limits on their plea bargaining, the process, the timeline. Like you get the offer and that's it. It's a take it or leave it. You know, not so much a back and forth. And when it expires, you're not going to get a new one. These can be, you know, factors that contribute to why the FBI has, or why the Department of Justice has a very high conviction rate, but it's also because the FBI has a ton of resources. And so the FBI can really throw a lot at any particular case in the process of building it. And yeah, just come up with pretty overwhelming, you know, evidence that would tend to support that position. So I think it's less that it puts pressure on the DOJ to convict as much as it just gives the DOJ means to convict when they do decide to go forward. Cassandra S. Hubby experience with materials engineer poly C exploding equals a little poop emoji. Yeah. I wouldn't know, but materials scientists would know. Seems like we'd want people with, you know, materials science backgrounds to be testifying to this jury if we're going to evaluate this theory. If we want this to be a truth-finding process, wouldn't we get that information out to them? Horror Vibe 666. List your qualifications, Trooper Paul. I'm wicked bald. Maybe that's all it takes. Z. Judge Bev may have been a public defense attorney, but what is the plea deal out of trial settlement record for Canton? Did she work in favor of the Commonwealth? So way back, remember I did a little breakdown of Judge Bev's record on appeal. And one of the reasons why it took me a little bit of time to do that and sort through that is because actually when you go in and just search Judge Bev by name, the majority of what comes up is related to her work as a public defender. You have to sort through the ones where she was, you know, she was a public defender, rule those out, and then, you know, get to the ones left where she was acting as a judge. So I can't, looking at that, say Judge Bev is a truck. I can't look at her and say she's a truck. She's just there to get a deal, for the Commonwealth and plead her people out, because you can't plead out and then appeal. You waive your right to appeal when you plead. You waive the ability to do that. So you appeal when you go to trial. So she's got a lot of appeals on her record. She was going to trial. But that said, the dynamics change when you get on the bench. Talked about the politics of this a lot. Law enforcement, a lot of power. She's appointed. These are appointed positions in Massachusetts. So, she had to make the right friends, hang out with the right people, get the connections to the governor. Law enforcement is a good pathway to do that. We've kind of seen, these connections already between, Berkowitz and state representative and just all these little like incestuous kinds of interminglings between people. And then the law enforcement is who you are dealing with. Law enforcement is calling her up on the phone in the middle of the night to ask for search warrants, Prosecutors are in her court every day. Mr. Yannetti may have never been there before. He may never go back. So the dynamics are quite a bit different when you're on a bench than they are when you're in private practice. And there's just a different set of incentives about who are you pleasing. The big reason why I loved being a public defender is because you get to just serve the interest of what is the right thing in that case. My client isn't paying me, so I don't have an incentive to just do whatever my client wants, because otherwise they'll fire me. Go ahead and complain. It doesn't matter. I have to do what I think is right in the case. And that gives you just a lot of, I think, freedom to behave in an ethical way that so many other parts of the legal system they lack. The incentives are to cut corners, not disclose things, suppress stuff, But that changes. That changes when you go on the bench, because you got to please the people who put you there and are going to keep you there. You got to please those people. Horror Vibe 666. We need Bukkake to count Judge Bev's vodka drinks. Yeah. What do you think he's suddenly gonna develop a little selective blindness? I couldn't see anything. She could be literally having the Tito's bottle there at the stand. I didn't see anything. Lauren Boborin, Bev not reprimanding Lally because she directs his case. It just looks like that more and more every day, telling him what to do, which question to ask. Why don't you challenge this issue? She is a prosecutor in a robe. Horror Vibe 666, Bev, Lally, please ruin your reputation differently. I don't like this way. Do it this other way. Rube gifted some memberships. Thank you, Rube. Very generous of you. Welcome to all the new members. Kyle Cowden, it'd be a blast for a jury for KR, thousands of runs. I think it would be a fun jury to be on myself. I would just love to be on any jury, honestly. I don't care. I would love to be on a jury, but I can't even get a summons. James Casatelli, I'm late. What did I miss? More of the same. Nothing you really didn't expect. The defense has highly qualified people to testify about very specific things that are pretty devastating to the Commonwealth's case. So Judge Bev is running interference and trying to help the Commonwealth come up with reasons to keep them out. Kyle Coden, any recourse beside appeal if Bev excludes anyone? No. Appeal is the remedy. They could try to appeal interlocutory, but it's not going to happen. We've only got like a week of trial left anyway. Nothing would get decided in that short of a time frame. So, nope. Recourse is appeal. Anton Ivanov, KR just said that she wants to testify. I've been saying I hope she does. Everything else being equal, I want a defendant to testify. If they're not If they're not going to tank themselves with inconsistencies and trying to like wiggle out of problems with the evidence, yeah, I want them to testify. The jury wants to know who this person is. And the jury is very forgiving. The jury is very understanding. At least this is my experience. I told the story before about my convicted sex offender client I put on the stand to explain the circumstances why he didn't register. And they didn't sit and go, well, I don't believe this guy because he's a convicted sex offender. No. He presented perfectly fine. And, you know, I mean, such as it is for a guy who's homeless and, you know, living on the margins of society, didn't come across as a bad guy, just a guy who was trying to do it, trying to work within the system, and they were playing games with him. And yeah, the jury did not hold his past against him in that situation. So that's my experience. The jury just wants to know. They're not going to judge you on your personality. They just want to understand it better. They want to see how all the pieces fit together. And she is such a fundamental part of the piece, part of this puzzle, you know, for them to figure out. They want to know. I want to be able to give them that, if that's at all possible. William T. Swanson with a super sticker. Thank you so much. Appreciate that. And RRGMRG1. I'm not going to try to pronounce that one, but with just the straight super chat. Thank you. Entry required. Dr. Russell reached out to LA DA because of a known mutual relationship with Boston DA. Jackson was informed secondarily. Yeah, she knew. She knew this guy. She reached out to that guy. That guy knew Jackson. This wasn't something that Jackson initiated. So this does not get in the demerit column for the defense. It's not a situation where he hunted her down and then sandbagged the Commonwealth. She appeared voluntarily late in the day. Duncan, Idaho, reminiscent of Dr. Corcoran in the JHACH Kowalski case 2, and that guy did it for free. I don't know that case. I'll have to look it up. Not familiar with it. But yeah, it is not that uncommon for people to step up and volunteer. Told the story before how it happened in one of my cases. I had it on post-conviction. Attorney had gotten an order to approve funding to hire a DNA expert in a case that involved touch DNA, trace DNA, and never consulted with him. And so after my client got convicted, he's in prison, he contacts this expert. And the expert volunteers. Hey, I'll take a look at this. No, the guy never reached out to me. I'll give you a statement. He was extremely helpful. And basically because he did that, he gave a declaration that said, had I been, had they consulted with me, had I been contacted about this, and had I seen what's been provided to me in these DNA materials, I would have said this is a very low quantity and quality of DNA that is consistent with contamination. And so had that guy not done that, my client's still probably sitting in prison on a life sentence. But because of that guy, his conviction got reversed. King Ginger 333, is it true that Bev knows the Alberts and fought to be on this case, then she refused to recuse herself when that information came to light? I don't know all of the ins and outs of the background. The only thing that I know about it, I know that they did move to recuse her. I don't have that motion. I haven't read that one. If somebody has it or knows where to find it and wants me to take a look at it, I would be more than happy to. But I haven't seen it so far. The only thing I know of as far as the, ostensible connections between Bev and these other people is the stuff on either Twitter or Facebook or something like that, where one of the Alberts is who referred to her as Auntie Bev. That's where the nickname comes from, Auntie Bev. Turtle Boy had said something about how you're all going to be in prison when the judge finds this out. And this member of the Albert family, I think it was Tim Albert, but I could be off, says who, Auntie Bev, whose beachside beach house or beach condo or beach cottage do you think we're going to bury your corpse under? I can't really hold that against Bev too much. in and of itself, just because it's one of those things that happen. It happens when you're a lawyer too. People are like, people tell other people that you're their lawyer and that you're going to do things, and like maybe remember this person from grade school or something, like haven't talked to them. It's not uncommon for that type of thing to get misrepresented or fluffed up or whatever. So I can't hold that in particular against her. If there's other indications of connections, though, yeah, it's concerning. It's concerning. She's a Canton hometown girl, isn't she? I mean, that's part of the just wrinkle in all of this, the whole towny angle of what's going on in all of this. They did move to recuse her. I do know that, and she did deny it. So that's about all that I know as far as the details there. RRG MRG1. I want to try to pronounce it, but I can't. What exactly is the FBI's role in all of this? Who called them in? Will they continue their investigation after this trial? It is ambiguous. It is murky. We don't know, because the only reason we know about the federal investigation is because the defense made a TUI request. They became aware somehow that the feds were also investigating these circumstances, the death of John O'Keefe. The speculation is that it has something to do with investigating public corruption. That is something that the FBI does investigate. They brought plenty of prosecutions about that. Rod Blagojevich is just, off the top of my head, a situation. There's a case I put up in my Substack in the comments just the other day about corruption prosecution that they did down in Hawaii just a couple of years ago. It had some kind of similar themes with, fabricating evidence and interfering with witnesses and things like that to protect the personal interests of the people involved, who included the prosecuting attorney in that case. So just a little bit of an interesting read there. So that is the speculation, but nobody really knows for sure. So it's not a situation where anybody called them in. This wasn't like, a local law enforcement investigation where they call in the feds for assistance. They need assistance. They need more resources or things like that. This is not Koberger. This is not the Moscow, Idaho situation where they were working together. It seems to be a situation where they are not working in concert. They have reached very different conclusions from the state investigation. They have said so explicitly in at least one of those responses to Mr. Morrissey's letter. So I don't know what the status of their investigation is and whether it will continue or not. If it has something to do with something like corruption, yeah, I'd expect it to continue. I would expect this trial, they would be watching it. They would be seeing what people are testifying to. They would be following up on that. They would be looking to see, is there perjury in any of this stuff? Is there other things that we can get access to that would establish this is perjury? Are there things that haven't been turned over already that would establish perjury or establish corruption or something like that? It's just one of the other, especially with perjury, it's just one of the other tools that they have, to bring to bear, to bring that pressure. If you can prove somebody committed 20 crimes, there's a lot better chance that they might go ahead and plead guilty to 5 of them, So we all want to know. We all want to know what's going on with the federal investigation, but there just isn't that much public information available about it. Be rational and nice when in this global sandbox. Boston brawl, court rules different than other courts. Every court has a culture, in and of itself. I don't particularly have a problem with that. I'm okay with courts having different cultures. Some of them are going to be very genteel. Some of them are going to be a little bit more rock and roll. But what we don't like is just the inconsistency, The rules being good for one side, but not for the other side. KRM 944, if you lead a trial like this, how would you curate crowdsourced ideas, counsel, evidence? Is it the future? It's a double-edged sword. It's a double-edged sword with the crowdsourcing of stuff, especially in high-profile cases, because everyone would love to be close to it, right? Even in cases that are just locally a big deal, you get overrun with information because everybody wants to be the person. I knew the guy that that did this or just whatever. It's this very just strange phenomenon. So there's a lot of noise. This is like a signal to noise ratio kind of situation. Being able to sort out what's good is very time consuming. And so it just becomes a cost benefit kind of analysis. Is it worth the time it's going to take you to sort through all of this bad stuff to get to the few nuggets that there might be in there? It gets harder and harder to, like right now, we have so many eyes on this case right now, so many people paying attention that are going to have different information and different ideas, different expertise, different approaches, all that type of stuff. All these people might have something to say, but it's late in the day, right? We got this Rule 14 issue now of trying to be able to overcome that potential hurdle. It wouldn't surprise me if in a lot of cases, there is somebody in the lawyer's office, maybe an intern, paralegal, somebody like that, whose job is to monitor media, monitor social media, try to see if there's anything like this that comes up. But, yeah, it's just a complicated sorting process of really what's legit, what's reliable and what isn't. And you just run the risk of spending a lot of time on things that don't pan out. And time in lawyer terms, time is money. That's money. That's your client's money that you're spending on stuff. You want that to be productive. You want it to be fruitful. So, it's just a line. It's just a line that you got to try to balance on. It's tough. I don't have a better answer for you. It's going to depend on the case. It's going to depend on the profile. It's going to depend on the issues. It just depends. Franz Marx, between divining the crime scene and appearing, disappearing apparitions, maybe the trial should have been conducted in Salem. Yeah, Amityville. Are we in the Amityville courthouse right now? Something like that. It's just kind of silly what is being okay and what is not. John Beatty Bott, Bev in holding trial over unanimous continuance effectively kills prosecution given FBI accident testimony. Is that why she helps Lally of guilt? It's my recollection that did the defense want a continuance that was denied? They made them go forward on this time frame because all of this stuff came out late in the day. Again, I didn't follow much of this case before the pretrial motions. The motions in limine is when I really started paying close attention. So I only have kind of a vague perception of what the case history background was up to this point, but I do vaguely remember, yeah, the defense had wanted a continuance. And so I'm seeing in the comments, both of them wanted a continuance, and she said, no, we're going now. Well, yeah, this is what happens then. If you aren't ready to go and you make us go anyway, then stuff comes up midway through trial, because it's not like we're going to stop trying to be prepared just because trial is underway. And then you have all this short notice stuff that everybody has to scramble to try to respond to. And particularly with the FBI, when, yeah, there's limits on what you're going to be able to access. They're not going to just open their file to you. They have gone through and selectively decided this stuff isn't going to damage our investigation if we reveal it. This side, there's a legitimate reason for either party in this lower case to need it. Just all the factors that they go through with a TUI analysis. They have done that with what they've done, and with what they have ultimately decided to produce. So there's no way to force more than that, And yeah, then that means whatever else the feds are doing right now too, if anything, well, they're just doing it. Maybe we'll find out about it. Maybe we won't. But yeah, it's a possibility. It could. Absolutely a possibility. There could be late breaking stuff. The FBI information, absolutely no question, it hurts the Commonwealth. You know, so in that sense, not granting the continuance isn't really doing them any favors either. It's just kind of doing her the favor of getting it off her desk. When you don't grant continuances when both parties agree to it, that's a red flag to me. That's a big red flag, because Judge, you're not involved in the ground level preparation of the case. You're not involved in the investigation. You don't have the discovery. You just know what they tell you. And so for you to be substituting your judgment for theirs about what needs to be done for the court to be ready, well, it's just very consistent with this micromanagey, control freak kind of approach that we've been seeing from this judge. At least I've been seeing it. I've been calling it out pretty much from day one, telling him how to ask the questions, not letting him ask the question that way. Here's how you should present your motion. I mean, red flag stuff. Franz Marks, Andrea, patronage within the court system in Massachusetts is the first consideration when retaining a litigator. Yeah, it wouldn't surprise me at all. It's going to be like that anywhere. Who you know matters a lot. It matters a lot. We'd like to think, oh, it's just on your merits. What's your record? Are you a good lawyer? Do people, have you gotten good results? But no, there are all of these other considerations that have to be in play. You don't want them to be, but that is just the reality of the system, and you're not playing the game effectively if you're not taking that into account. Because yeah, some people will look at who's in the courtroom and who they know and how will this benefit me in the future, depending on how I rule. So it's a shame that that's how it is, but I can't say I'm surprised that that's how it is. Still Raven, SOP for our criminal injustice industrial complex. Yeah, well, justice is a secondary consideration here. Finality, getting things done, that's the primary concern. Let's just close the file, check the box, and call it done. Doesn't matter if we got the right person or not. That's why I've been saying from day one, she gets acquitted, never will anybody else be charged with this. The approach is going to be, well, the jury got it wrong. They're going to be committed to that until the bitter end. And if they don't get their conviction here, the jury got it wrong. Horror Vibe 666. Other cases fed evidence helped the defense. Oh, I'm sure that there have been some. I'm sure there have been some. This is definitely not the first TUI process, that's ever been out there. You can make the argument right now that some of the Fed stuff is helping Brian Koberger over in that case, because it's kind of showing, it's less maybe what they do have and more what they're not showing that is revealing the limits of the analysis they did and the conclusions that they could reach based on that. But the TUI process is not, it's not new. What is very unusual from my perspective is for them to be so forthcoming with an open investigation. It's just a free out for them, because that's one of the basic factors they have to consider is this going to interfere with a pending investigation? And you pretty much have free reign in law enforcement to say, look, any information I give out is going to tip my hand. So I got to keep everything close to the vest. This is why public records acts all over the country have this exemption for, these are public records, but until the investigation is closed, you don't get to see anything about it. You don't get that information. Because it can jeopardize the work that they're doing. So that's a big deal. That's what got my attention here. This is an open FBI investigation and they're handing over all of this volume of stuff to the defense. That is quite unusual. I don't know of another case off the top of my head where that kind of thing has happened. Unhung Hero, what are the odds of Karen walking and Turtle Boy serving time? Well, I don't know that Turtle Boy has the defense resources that Karen does. I don't know that, I mean, not that he's got a bad lawyer or anything. What I've seen of his lawyer so far, he seems quite competent. And I guess maybe it's a little bit of a different situation too, because, you know, he doesn't need to hire accident reconstructionists and, you know, dog bite experts and people like that, fly them over, you know, to be able to testify and stuff like that. I haven't looked that in depth into Turtle Boy's case. It's been, I mean, I'm aware of it, and, you know, I'm definitely aware of the perception, which I side-eye myself, that, wow, this really looks like you are you're being punitive. You're leaning on this guy because he's out there publicly advocating for Karen Read. I mean, I've seen a lot of the things that he did. Do I like all of it? No, not my style, but does it seem to be his right? Yeah. What I've seen so far seems to be his right. I did take a look the other day. I just saw for the first time the search warrant affidavit. Somebody posted it. They did a search warrant for Karen Read's phone, but it's arising out of Turtle Boy's case. The warrant that I saw is just permission to seize it, not permission to go into it. It's a 30-some page affidavit. Totally wrote it. And the overwhelming impression I had of it is like, wow, look how much work they put into this compared to the work they put in to investigating John O'Keefe's murder. They put a lot of time into putting all this together and getting all these witness statements and pursuing this investigation. Witness intimidation, I don't know what the Massachusetts statute is, but typically it is going to require some kind of threat. Like, you know, when you're talking about threats, you always have First Amendment limitations. So you're talking about true threat, serious expression of intent to inflict death or severe bodily injury. You're typically talking about a threat. You're talking about a course of conduct that is designed to harass, or, you know, otherwise it just has no legitimate purpose. You're just being an ass. You're there to try to scare them or whatever. And typically it needs to be directed to influencing the witness to testify falsely or to absent themselves from the proceeding, you know, not show up to the subpoena. None of this prohibits saying, I think you're lying, and I think you should change what you're saying, because I think what you're saying is a lie. That's not unconstitutional. That's not illegal. So a lot of First Amendment implications in Turtle Boy's case, and I'm not sure that they've really been all that fleshed out at this stage so far. So I can't say the odds are bad at this point, because frankly, I think odds are very good that Karen is going to walk. With Turtle Boy serving, he already did 60 days. Wasn't it 60 days, something like that? 2 months that he spent in jail. He's already done time for this, so already done more time than she has. Lying Eyes with a super chat. Thank you so much. RRG MRG1. I think this means what happens if they find her guilty and the FBI has exculpatory evidence. Are the feds required to turn over evidence either way? So no, not if they are not part of the prosecution's investigation. If they are working with the prosecution and investigating the state, then they can be considered agents of the prosecution, and then they are subject to Brady Giglio. These are the requirement to turn over all exculpatory evidence in the hands of the prosecution. It's a matter of due process. You don't get to hold back the stuff that would prove the defendant didn't do it. You have an affirmative obligation to turn that over. But that's not the situation here, as far as we know. They are not helping the Commonwealth, so they're not agents of the prosecution. They don't have any independent obligation to turn stuff over. Their obligations are limited to TUI, and their TUI obligations are in and of themselves pretty limited, and you don't necessarily have a lot of recourse otherwise. Like if they don't follow the rules, you might be able to sue them for an Administrative Procedures Act type of violation. You know, arbitrary and irrational type of execution of their rules. But other than that, no, you don't have recourse. You really don't. They get to do what they do and keep it private. And until they come and prosecute you, they don't have any duty to turn over really anything at all, and not exculpatory stuff. That said, you would certainly hope that they would. You know, you would really hope that they would. But I know I see this. Carazola X, the feds are the good guys. What a backwards world Karen Reed is living in. I'm not used to this. I'm not used to this orientation of characters in the story. I'm not used to the feds being the good guy. I'm used to the feds being the ones that are overstepping, and the DOJ being the ones that are hiding evidence and fabricating evidence and committing prosecutorial misconduct and all of that type of thing. I'm not saying the feds can't ever be good guys. It's just, very clear. I come from a defense background. That's my experience. So that's just typically what I expect to see. All right, guys. Well, no court tomorrow. No court tomorrow. We get Juneteenth off, and then we're back on Thursday. We'll finish up with Trooper Paul Ryan there with his cell phone extraction. Saw other people say he looks like Anthony Weiner. I can kind of see that too, but I get very strong Paul Ryan vibes from the guy. I don't know why, like a long lost cousin or something like that. It's one of those things, if we talk about the mitochondrial DNA, and how you can trace that because it goes through the maternal line, right? So it's daughters of daughters of daughters of daughters of daughters. And that means you can go back many, many generations to where there's a common ancestor, but you'll share that same mitochondrial DNA. You might not be related like at all by today's standards, but that's all it takes to get you that genetic connection. And in the meantime, over the generations, yours moved over here and had children with these people. Yours came over here and had children with these people. Just all of this intermixing of populations. But as long as it's daughters of daughters of daughters, you're sharing that same core back to that common ancestor. Maybe there's a Paul Ryan and Trooper Guarino thing like that going on. Somebody, 10, 12 generations back with some really strong, like thin lip vibes. I don't know. So we'll get him on Thursday. I have heard that the Commonwealth is supposed to rest as early as Friday after Trooper Guarino. We are finally at long last going to get the medical examiners, and that will be that. And then we will get the defense case, and there will be much rejoicing. Can't wait to see what they got. I can't wait. Mr. Yannetti, I have faith in him to keep his promises. He has kept his promises very well so far. He wasn't afraid to make them, and he has kept them. So when he told me, you'll be glad you did. Wait for us, you'll be glad you did. I am looking forward to being glad that I waited for the defense. So hopefully we will start to get to see that soon, guys. I will look forward to seeing you back on Thursday. Thank you again, everybody, for being here. We had a really big crowd today. I don't always track like what's going on, but I just noticed, holy cow, the chat is really flying here, and there's like 7,000 people all watching this at the same time. It's quite a crew, guys. I really appreciate all of you and all the just fantastic contributions that you have. It's really been a gold mine of information and perspectives. I love that we're able to have that kind of environment here. We're here to think critically, We're not here to say what anybody has to think. I want to hear what other people have to think. I love when people have really good reasons for disagreeing with me. It's like one of my favorite things ever. So I enjoy the conversation that we have going on here. And gonna enjoy a little time off tomorrow. Be back at it Thursday, guys. Hope to see you back then. We are getting close to the finish line here. We're getting close. So I will look forward to seeing you bright and early on Thursday morning. Take care, everybody.